Talk shoes. Recorded live.
Hello, everybody. Give me a few minutes here and we'll get people blocked out and locked in. We'll get started here with any updates and bring you up to speed what's going on here and stuff that you people need to, we need to think about real seriously here about what's going on here and what power Congress actually have and what power these people have and how to address some of this stuff. Because, ladies and gentlemen, we got some good people out here that is working up on this stuff, and it's good. But we need more people involved, and we need more people to file and start bringing claims in on these criminals that is not holding their jobs in good honor and in good behavior in these public offices. And not all of them are, but we do have a lot of them that is holding their office in bad behavior. And we need to address some of this stuff. Harvey, got any updates? Go ahead, and we'll go ahead and get started here.
Okay. Hi, Rod. Hi, everybody. If you're new to the calls, and there may be some new people on the calls because what Rod's been doing has been getting out there, and a lot of people have been forwarding the big lists on to other people that were not previously aware of what Rod is doing in D.C. and in other areas. Anyway, get on the big list, and the big list will keep you updated as to when there are calls, when there are new documents, when there are private calls that Rod does occasionally, etc. All you do is send an email to Rod, R-O-D, -class, C-L-A-S-S, -subscribe, S-U-B-S-C-R-I-B-E, at rayservers.com. Ray Servers is spelled RAYSERVERS.com. Kind of like a guy's name, Ray Servers. Ray Servers is plural, so it's Rod-class-subscribe at rayservers.com. You'll be part of a group of 1,800 plus people that are on the big list and who get these emails when they come out and stuff like that. Anyway, big week for you, Rod, huh?
Yeah, it has been.
I'm glad you survived it.
Yeah, so am I, and so is my wife.
Yeah.
She was about ready to do me in if they didn't.
Yeah, so you would have gotten it twice.
You got that right. You know, she's worried a lot here because there's a lot of stuff. I tell you what, she's starting to understand what we're doing and why we're doing it. Because for her not to know anything at all about this, not having any history, any knowledge on any of this is all new to her because she was one of these that, it's like I was when I first started out. I believe the system was honest. I believe there was integrity. And I believe if you told the truth and you were very polite, things would go your way. And she's got a very rude awakening that honesty and being truthful and playing it straight with these people don't mean squat. Because they're going to go do whatever they're going to go do, and they act as if they are incompetent. And I'm using the word act, okay? Understand that word act. I'm not saying that they are. They act as if they are. But you try to put on that same show and that same mentality, they're going to hand your butt to you on this. And this is where part of the problem's coming in. But this whole thing got escalated over a traffic stop here in Lincolnton over a seatbelt issue.
And your traffic stop is by State Highway Patrol officers, right?
Yep, it was State Highway Patrol officers. It was one that he listens to the show on a regular basis. He is on here probably tonight listening. He downloads these things. And the thing is, he should have known better. Should have known better. He knows I'm peaceful. He knows we're trying to come in, we're trying to educate. It should never have escalated from verbal to a gun pulled and cocked. It should never went that far on his side of the fence, okay? Because there are what is known as rules of engagement or rules of escalation that these guys are taught. And I know this to be a fact because my son, through his military history, had to pull patrol duty. And on military bases with some of his background, he's had to have police training. He's had to have military training. And the rules of engagement on this thing is if you come across a citizen, you verbally talk to them first. If they don't come in compliance, it goes back into the situation. Some people out here, they get aggressive with the police officers, okay? And that's a mistake. But they get aggressive. They get violent. They get hostile. That police officer does have a right to defend himself. And then don't take what I'm saying wrong here. They do have a right. If you're being aggressive here and you are threatening them, you got a club, you got a knife, you got a gun, you got a beer bottle, they do have a right to defend themselves. And the escalation setup is this, is verbally talk to you. Second step is to hit you with mace. If you keep coming and you are being a bull in a china shop and you are just dogmatic, you're going to. The next step is a nightstick. If that doesn't stop you and you keep coming on, then it's supposed to be the taser. And if that doesn't drop you and you keep coming and you are going to do bodily harm, he has a right to shoot you. But see, none of that happened. I was standing there very calmly inside the door. I got out of the car, but I had the door open. So I was in the doorway, and when we got into this, so there was no aggressiveness on my side, other than I was sitting here saying, hey, you can't do this. You don't have a DOT on what you're doing. I'm not in commerce. And I was asked for my driver's license. I was asked for registration, and I had my wallet and had my keys in my hand, and I wasn't thinking at the time, and that was my mistake, and I didn't think about it until after I had a chance to think about it. But I reached behind me and hooked my keys on my belt pants because if anybody who knows me, they know I always wear my keys in the back of me. At which point he pulled a revolver. At that point, it now came down to where he has now charged me for resistance. Now, wait a minute. Stop and think here. I was charged for resistance. Was I placed under arrest? No. Reaching behind me and putting my keys back here went from verbal to pulling a pistol. It still went from a peaceful situation, where it got escalated on his side of the fence. And if he would have stopped and thought about what he was doing, he should have never pulled his pistol on this issue. Because he knows I was already under orders not to have, and if he listens to this show like he says he does, then he knows I am playing it straight on this show, And I'm going to play it straight out on the street because we're trying to sit here and set a precedent of trying to fix the problem out here. We're trying to address this issue very peacefully with these guys. And trying to talk with them and sit down saying, hey, you know, you're violating the rules here. You have Highway Safety Act regulations. You got rules for commerce. These things should have been taken into consideration, and these things should have said, okay, because he sat down and says, Rod, I know you. I know who you are. I listen to you. You and I have met 5-6 years ago. I still can't place where I met him at. But if he knows me that well, because he says, I know you better than your mother knows you, then he should have never pulled his pistol. He should have never pulled his pistol. But this thing has escalated on his side of the fence because he took it out of text. It's one thing for him to have not known me, but for them to know me and understand what I'm doing here for this to happen, this was totally uncalled for on his side of the fence. But what it did, it caused a reaction in D.C. because when this happened, they called the probation officer and they wanted to know if I was on probation or parole. I said, neither one. I'm not on probation. I'm not on parole. I just got a ankle bracelet on, but it's under a bond. Because I'm not under probation or parole, because number one, I was never found guilty. I haven't had a trial yet to be put on probation or parole. So therefore, this was a bond issue. But nevertheless, they called D.C. And I ended up getting a court order, which Harvey pulled out that on the 27th I had to be in D.C. So we went up to D.C. We got into the court, and basically, everybody was congenial with me on this. That this was, I've got a good record. I've got a good behavior record. I'm not out here trying to create a problem. I'm doing what I'm supposed to be doing. And I was basically given a reprimand and sent back home, which is where I'm at now. But also the judge up there sitting here and told me that I had to answer the prosecutor's response from last month. Because when we was in there last month on the 17th, he had to answer my paperwork, my in-camera hearing paperwork, and he had to address it. Well, the only thing he did was give a chronological commentary of a timeline, which you people have because Harvey put it out. Within a few days, Harvey and I got the paperwork up, and we did a squash on his paperwork, and we went back in and filed an ultra-virus misbehavior. We filed a formal complaint under ultra-virus misbehavior on him. And some people ask me, why did I file a formal complaint under ultra-virus? Ladies and gentlemen, I want to walk you through some steps here, and I want you to think about what I'm going to tell you. One of the main issues that we have out here is the fact that, number one, at no time has there ever been a formal complaint against you on any stop or any activities out here in the road or even within the banking system. Anything that deals with a warrant. There has to be a formal complaint. Criminal Rules, Civil Procedure, Rule 4 clearly states this. The Fourth Amendment of the Constitution clearly states this. You get into your different states for your warrant laws, and they clearly state this. You get into your Rule 3 of Civil Rules of Procedure, and they sit here and tells you there has to be a complaint filed can be started. There has to be a complaint. Now, what part of this doesn't anybody understand? Especially on their side of the fence. There has to be a complaint. There has to be done under oath and affirmation. There has to be an affidavit. Upon that complaint, upon that oath and affirmation, upon that affidavit, then there is to be a warrant issued or a citation issued for you to come forth into a court hearing and address the issue. These are their rules. These are their regulations. These are their guidelines. This is how this stuff is wrote out. And all this stuff is being bypassed on their side of the fence. What they're doing is they're coming out and they're, well, we got probable cause. No. Go back and read your rules under warrant. Even under a probable cause, there had to be an official complaint. Had to be somebody that signed it. Had to be someone that had an injury, even under a probable cause, before a warrant can be issued. This was the issue with the State Highway Patrol. Was there a warrant? No. Was there a complaint? No. Who's the corpus delicti? But don't go there. Yes, I'm going there. Who complained that I did not have a seatbelt on? Besides, I got a medical release from a doctor that sits down and says, I can't wear one due to the medical condition that I have. But none of this was adhered to. But when we got into D.C., part of this was brought up, and it was showed to the judge that I can't wear a seatbelt because of the medical condition that I have. And while I was up there, I had a mild attack while I was up there because of the weather being so cold flared this thing up. And, of course, the stress and strain with what we're dealing with didn't help it out any. But the cold weather sort of kicked this thing up on me. And it's put me down for the last several days, and I'm still not up to speed. But the point being of it is, with everything that we're getting into, ladies and gentlemen, procedure on their side of the fence has to be followed. And this is why we came back in and we filed that formal complaint for ultra-virus misbehavior. Is that we're laying out their screw-ups. We're laying out their procedural violations. And then when you follow it up with that notice of felony, that these are the crimes that's being committed, these are the charges, and you do an affidavit and you get it notarized and you get it signed, and I filed my end of appearance, therefore the prosecutor's response was already answered long before we got into court here this last week. And while we was in court, the judge asked me, he said, well, Mr. Klaas, well, she told me, said, Mr. Klaas, you have to answer this man's paperwork. Well, the paperwork was already answered. It's already been answered for about 2 weeks. It's sitting in there.
Right. And your paperwork, when you answered him, I think you complained that he didn't do what the judge had asked him to do, which was to rebut your stuff, right?
Yeah, we went back in. We stated that he did not comply with the judge's order. The judge told him to answer my paperwork. The judge did not tell him to give a chronological time order of what was going on here. He was told to answer the paperwork, not a time order, not a commentary of what was on the docket sheet.
Right, that everybody already knew.
Yeah. So we already had this in there before she told me to file. But when we went in there that Wednesday, or Thursday, but we went in there that Thursday, Harvey and I already worked up a document for I filed another formal complaint of ultra-virus misbehavior with a counterclaim. Again, it comes down to is why are we doing ultra-virus formal complaint? Because, ladies and gentlemen, we're following the steps filing a proper complaint into the court. Now the prosecutor has to address it. Technically, the prosecutor should be picking up that complaint and said, that's okay, Mr. Class brought a complaint against the government. He should now be picking up that complaint and bringing charges against the government because we put in a proper complaint of misbehavior under ultravirus. That's what he should be doing. If he isn't doing it, then he's going to have to come back and he's going to have to answer the ultravirus issue, and he's going to have to go back in and show all the misbehavior side of what they've done. He's going to have to go back and prove that they did not miss a lick and they didn't do any of this, and he can't. So again, no matter what he does, he's not going to be able to answer the paperwork, and he's going to hang himself.
He did, didn't he?
Yes.
How did he hang himself?
Well, what I'm sitting out saying, if he tries to answer that ultravirus paperwork, because of the way it's written out, and we're showing their procedural errors, he either is going to have to admit to the procedural errors, at which case he hangs himself, or he's going to have to look at this complaint and says, okay, there's a formal complaint filed properly before the court. Now I have to act on it, and now I'm going to have to go out and prosecute myself.
But he did get in trouble, though, because he is no longer, now we've come to find out, he's no longer the prosecutor, is he?
No, he's not. They replaced him. They did replace him with another one. So far, I've got a second judge. I've got a second prosecutor.
Yeah.
I've got basically a third public defender, but we're working on it because I asked him to be relieved because he's ineffective, because he wasn't doing his job right, and that's why I filed my interference into this thing, which was accepted. It was accepted. So
we saw the order where she signed it, where the judge actually signed Rod's entry of appearance.
Yes, she actually signed it. So she has recognized my interference into this thing. And this, ladies and gentlemen, this is one of the biggest things we've got to be able to go do, is we've got to be able to do the interference into these cases in order to get ourselves into these things and be able to address their wrongdoing. Now, I don't know what's going to come out of this, but I know I got to go back on the 26th of March for one more status hearing. And Harvey and I right now, we're working on some paperwork. And as soon as we get it done, we're going to get it filed in. And we're going to see on the 26th what the judge does with this on the 26th. Because technically, what's supposed to happen here, ladies and gentlemen, on any of these status hearings, it's not their normal procedure. Basically, they just keep their mouth shut and they just shuck and jive on this stuff. But during these status hearings, your defense is supposed to be coming in and addressing the court and saying, Your Honor, Mr. Class here or John Doe here, I need to make an issue before the court that there was no proper complaint filed that brought a claim against this party. There was no proper warrant filed before he was arrested or she was arrested. Procedure was violated on the police department side.
Right, this is the D.C. Police Department. In other words, Rod, are you saying that the D.C. Police Department did have to have a complaint against you and then a warrant issued by a judge to have arrested you the day they arrested you back in May of 2013?
Exactly.
And they did not, did they?
Well, they did not. They just come up. They come up and do what they always do. They just come up and arrest you. They bypass all the formalities. And this is why you need to why I filed a formal complaint of ultravirus misbehavior, because they're not following their procedures. They didn't follow the rules. You're getting something into the record here, ladies and gentlemen. you're laying out their procedural violations. And what is the part of this is the fact that the judge did accept my entry of appearance into this case and has allowed me to file all my own paperwork in, even though the public defender has not filed one stitch in my defense. She has allowed me, and she has ordered the prosecutor to answer my paperwork, which he did not answer it very well.
Yeah, that's right, because he's no longer on the job, is he?
So he's not. So he now put this other prosecutor in the hot seat on my paperwork.
Good luck.
Yeah, definitely on this. Definitely good luck. But we need to start coming in. We need to get better educated and have a better understanding of their rules and their procedures of what their guidelines are on all this stuff. And this right now is what has really tied my case up, because with me falling into that in camera for a hearing privately with the judge and putting in the paperwork, threw a monkey wrench into it, because they're realizing that I know a whole lot more. And one of the things that the state highway patrolman did, and I thought it was funny, and my wife knows, she's innocent on a lot of this stuff. She don't know this stuff. She really truly don't, and she just soon not know it. But he came up and he asked her, it says, "Where did Rod get his law degree?" And she says, "What law degree?" And basically the comment was that he has to be a lawyer or he has to be a paralegal. And my wife said he's neither one. Said he has to have a law degree. He said, "Rod don't have a law degree."
He can read, though.
Yeah, he can read, but he don't have a law degree. He never was a paralegal. He never went to college. He never got a bar card. Rod's never been to college. And they're under the impression for you to have knowledge, you had to have a degree or a college degree in law to know that. This goes back into the feudal time period of the lords and the servants. Only the lords have knowledge. The servants are uneducated. Well, this is one servant who learned how to read.
Yeah.
This is one servant who learned how to read. And this is what's got them thrown, because they're trying to figure out where I got my law degree. And I don't have a law degree. Never did. I never went to college for this. I got a 12th grade education. I got a degree in auto mechanics. I've got a degree in welding. You know, I went to technical schools, but I never went to college. I never got a law degree. I'm a jack of all trades. But this is what's throwing them, is they don't know how I'm coming up with this stuff.
Well, unfortunately, you're reading things that they should already know, like procedure.
Exactly. And that's really what this comes down to, is their rules, their procedure. And that's why I'm sitting here telling you people, you really need to understand their rules, their procedures on this stuff, because once you understand it, it's going to make it easier for you to come back and hammer them on your paperwork on this. And this is why, like I said, this is why we went under the ultra-virus misbehavior of a formal complaint, because we are bringing this stuff in under a formal complaint with an affidavit, with the criminal charges, and with an end of appearance into this thing. So we're bringing in under the rules and regulations of how to file a proper complaint.
You're sort of teaching them, aren't you?
Yes, we are.
Rod, one thing. Your public defender, who is AJ, what's his last name? Walker? No.
Kramer,
AJ Kramer. Now, if AJ Kramer was truly a public defender, he would have, you've already discussed with him what they did wrong, but AJ never went into the court and said, Your Honor, such and such procedure wasn't followed, such and such this, such and such that, as your defense for a motion to have all of the charges dismissed. He didn't do that.
No, that's the whole point here. This was his job. His job was to come in and argue, Your Honor. Mr. Glass has a Second Amendment right here. I realize we got the case law, but case law does not override the Constitution. Constitution is supreme law. The Bill of Rights is supreme law. We may have case law, but, Your Honor, that case law that only goes back in to deal with certain firearms. And, Your Honor, that's the other issue that I need to bring up to you, is that Mr. Class did not have a firearm. He did not have a modified shotgun with a barrel less than 18 inches, or a rifle, or an automatic machine gun, or a silencer. Therefore, I asked this case to be dismissed because Mr. Class did have a carry permit, and we have equal protection under Article 4 of the Constitution, and under Title 42, 1981, equal protection. And, of course, I'm going to throw in the 14th Amendment here, Section 1, equal protection under the law here. So the prosecution has really made a serious mistake, and we need to come back and address it and just dismiss this case because they don't have a claim.
Because it's a waste of the court's time.
Exactly. And ladies and gentlemen, that's the arguments that your lawyer should be making on your behalf. And because they're not, we have to come in and we have to make these arguments.
Yeah.
But see, again, with what we're getting into and talking about, that Constitution that was sent out, that was from congressional, and it even got into the Second Amendment. The Supreme Court in that Second Amendment has came back and ruled that the Second Amendment cannot be infringed upon. It is absolute. It cannot be denied. It cannot be infringed. But what they were addressing was Title 18, 921. And what they were addressing on this was the fact of the sawed-off rifles and shotgun, because they're classifying them as non-military weapons. They're classifying them as non-military. Now, they didn't say automatic machine gun because that is. They didn't say silencer because that is. But they're sitting here saying that's sawed-off. This is what they are creating law against, and this is what the prosecutor is taking out of context when you're being charged under a gun charge. This is what your lawyer should be coming in and addressing. Say, Your Honor, I object to this because it is very clear that the Supreme Court has ruled that the only thing that Title 18, 921 applies to is sawed-off shotgun and sawed-off rifle, because it's not military standard equipment. But those of you that were in Vietnam and were tunnel rats, a full-size shotgun did not work in a tunnel. So there was, and that's the same thing with in the trenches. During the wartime, World War I, you had trenches. But the point being of it is, the Supreme Court has ruled that Title 18, 921 only reflects back to sawed-off shotguns and rifles. That's the only thing it reflects back to. And none of these arguments are being put in by your lawyer, and the prosecutor should be sitting here automatically dropping this, because unless you are arrested and you have one of these items and you do not have a license for it and pay tax on it, then they got an issue here. But if you have a license and pay tax on it, they can't charge you. These are the understandings of all this stuff that we need to get in and understand as our defense to make arguments in this. But the other thing we need to bring up, and I want you people to think about this, and I want you to get into the Constitution under Article 1, Section 8. I want you to go back and look. There's only two arenas, basically, that Congress can get into and create laws. One is commerce, which falls under commercial and taxes. The other one is foreign affairs. If you've ever watched C-SPAN, you've never watched C-SPAN where they sit here and say, okay, we need to create a law to put a stop sign out here on such and such street, and we need to create laws against John Q. Public. Everything they talk about is commercial activities or foreign affairs. Obama just stuck his nose into Ukraine. Okay, this goes right back in. This is where they're supposed to be sticking their nose. They're supposed to be sticking their nose in everything but our business. Congress cannot legislate law against us because we're not dealing in commerce. Here again, it goes back into the name deal. And this is what I brought up on a show earlier today, is we need to attack the terminology of congressional legislation. How does this language apply to you and I? And it's like I brought up on the show, and I sit down and I talk to a lady here at the post office here today, and she's seen my Jeep. She says, bounty hunter. And I got explaining to her what I am and what I do. And she says, oh, my. And I got talking to her about the language. And I want some of you new people to sit back here, and I want you to sit here and think about what I'm going to sit here and say. And we're going to break some of this stuff down here. If I was to ask you for an example, what is an apple? The response would be something that grows on a tree. It's a fruit, something you eat. It's got seeds in it. It's got a peeling on it. And there's many different types. You got Washington red apples. You got golden delicious apples. You got crab apples. You know, it's the fruit. So now you and I have an understanding what an apple is. Okay, now Congress is going to come back in, and Congress is going to sit down and say, now we're going to use the word apple as a definition. When you read in any of the laws the word apple, it is to be construed to mean a computer. Apple computer. It is construed to mean a pencil, an ink pen, a crayon, a marker, set of paints. This is how the word apple is to be construed. Now, what does Apple computer and pencil and ink pens and crayons and markers all have in common? They all write. You're able to do a letter. You're able to sit down and you're able to create documents. That's an apple. But is that what you were taught in school? No. It's the same thing when it comes down to the word person. You and I were taught a person is what we are. We are a person. We are flesh and blood. We are human beings. We are, we're alive. And the USC codes and in the CFRs and in other legal languages, Congress has went back in and says, okay, whenever you see the word person or whoever, the word person or whoever, it is to be construed to have the following meaning: a trust, an estate, a corporation, an association, a firm. But they throw that word individual into this thing. But what does the word individual have with the trust, an estate, and a corporation, and all these other entities? And this is what we need to come back in, and we need to push the issue on that we want clarification under verbal communication of congressional language. Now we're coming in and we are asking the prosecution and asking the court, we want you to clarify verbal communication so when you and I talk, we're not talking fruit to computers. We're not talking fruit to computers here. We need to understand what the language is. And under Title V, like I told you people some time ago, under Title V, the word individual, if you go back in and you look it up under 552A, it reflects back to an alien requesting permanent residence. An alien requiring permanent residence. Now, how are you and I, an alien, trying to get permanent residence? Well, Rod, no. So what does this mean? Individual. Okay, stop and think here. Let's talk about IRS. IRS has you down as an individual, has you down as a trust, has you down as a state, has you down as a corporation. It has you down as everything else but a human being. So that word individual under IRS is that they're saying that you are an alien requiring permanent residency. But it also goes into citizen of the United States. Well, Rod, we're all citizens of the United States. Yeah, you better think about that statement you just made here. Because I'm going to walk you through this. I got into a conversation with a friend that has called me, and we got talking about this. He says, well, the District of Columbia is not part of the United States. I said, Yes, it is. The District of Columbia is, in fact, the United States. Because if you understand, and those who live in D.C., they know about the survey plot of the 40 stones that are laid around the District of Columbia. And on that stone, it is engraved. It says jurisdiction of the United States. Inside that 10-mile square, it's facing. This is the United States. This is the jurisdiction. This is the United States. If you look on the back side, it does not say United States of America, Maryland, and the United States of America, Virginia. It says Maryland and Virginia on the back side. The United States is not attached to it. The only place the United States sits is in that 10 square mile area. But Rod, we're called the United States. This goes back to another play of words. What I'm doing here is giving you people another line of thought, something to sit here to think about. And say, you know what, I didn't think of it that way. I didn't look at it from that point of view. And that's part of what this show is all about, is to give you another point of view to get you something to think about. So what would be the difference if I was to tell you the states of United or United States? The word united means all the 48 states on the lower level here were all united and were all states. So it comes back into play of words here. But if you go back and you look at the historical side of this, of the world map, and you was trained in school, Alaska, Canada, and this country was classified as North America. You got Mexico all the way down to South America, which is called Central America. And then you got South America, called South America. It isn't United States North America, United States Central America, and United States South America. It's called North America, Central America, South America. It comes back, it's a play on words that they're doing here, and we need to come back in and understand these play on words. And we got to be able to address these play on words that they're doing here. We have to start exposing the definition side of this thing of how it is intended and how does it prefer to me, and how am I a corporation, how am I an individual when it clearly sits there and says that it is an alien applying for residency, which I am not an alien applying for residency, or it talks about the citizen in the United States, which is at 10-mile square.
Yeah.
And if you go back and you look under Title 26 under IRS at 6331, again, that word person. Under that definition, if you read Section A, it only refers back to employees appointed or elected public officials within the District of Columbia. That is what is referred to as the citizens, or the people, or the person, or the individual. It is within that 10-mile square. This is something maybe some of you have not given any thought to, have looked at it from that point of view. But I'm trying to give you an ideal here of what you're looking at, and a way of being able to deal with these issues that you have, and to be able to address it. I'm also trying to give you how I'm looking at things. Whether it's right, whether it's wrong, it's a different point of view than you have been taught. And we need to start addressing these people with a formal complaint on our side of this thing. And that ultra-virus misbehavior is a real good way of coming in, because if you go back and read ultra-virus misbehavior, and it's in that one document of mine, it's right there on the top part, and let me pull it up here and I'll read it to you, what ultra-virus means. But it goes in and shows that they're not following their own rules, not following their own regulations on any of this stuff. That's what it says here for ultra-virus misbehavior. Wait a minute, that's the wrong document. That's the wrong document. Got so many documents on here trying to keep up with them all.
Yeah, your computer screen must be a mess.
Yeah, it is. Yeah, I've got so much on here trying to keep up with everything. But basically, what it gets into, ladies and gentlemen, is the fact that they're sitting here saying that the government cannot violate its own laws, and it falls back under the Constitution, because the Constitution is the maximum law of how it's supposed to be handled, and that the corporation cannot sit here and violate its own charter. And that's exactly what we're talking about here, that they cannot violate their own charter on any of this stuff.
And if they do and we don't object, they get away with it.
Exactly. But that's why we got to come back in and address this under the ultra-virus side of this thing and sit here and say, this is your definition, you can't do this, you can't violate your position, and this is what your job description is. But this is why it's important that we go do with what we're doing here and address this in a manner that we are addressing it. But it's up to you people to turn around and learn and understand and get educated in this level of what we're doing here. Because, ladies and gentlemen, it's taken quite a time for me to be able to understand, but we're trying to break it down for you to be able to grasp and trying to make it easier on yourself of what we're doing here. We're trying to make things easier for you. Trying to make it a lot easier for you guys to understand, to be able to come in and file your paperwork and to be able to argue this thing. Because there's so much out here that a lot of these people are doing, they're leaving half information off of what they're doing. Leaving half information off. And when they leave half information off, then it throws everything into a confusion on your side of the fence. But if you got the understanding and you do the history background, you do the history background. I'm telling you where it's at. I'm giving you the ability to come in and do. But I want you to do your own research. I want you to come in and I want you to understand it. I want you to be able to grasp it, because you're the one who's going to end up having to walk into that courtroom, and you're going to have to be the one who's going to have to address all this stuff. It's got to be me. It's going to have to be you. And it's the same way as what I'm doing now. I'm walking in because they have already admitted this thing has went longer than it should have ever went. It should have never went this long. But they because of what we're doing here, it has created such a problem with them, they don't know how to get around this. But she's going to have to address it here this next 26th. And she's going to have to set a court date. But I'm going to have to deal with the public defender on this side because he's nice, but he's not doing his job. And the thing of it is, whenever he has admitted that he is acknowledging that there is absolutely no defense on my side and that he has no way of defending me, then he should have stepped off the plate. He should have told the judge, Your Honor, I can't defend this man. I have no defense for him. Therefore, he should have stepped off the plate on this and either handed it over to me or found me somebody that could deal with it. But because he has not done this, he has hampered it, which now gives this thing an ability for an appeal and a notification of fraud upon the court. But ladies and gentlemen, like I said, there's a lot of information here. We're trying to get out as much as possible. We're trying to bring you up to speed on all this stuff. We're trying to get you as knowledgeable as possible. And I've had several people that come in and that showed up at the hearing, and I want to thank them very much for showing up because it was support. But they had the ability to see firsthand and had an impression, which I'm not going to get into on the air, but what they seen, they were disappointed in the responsibility of the people involved of doing their job right. It was very disappointed. These people actually doing their job right and actually showing some type of integrity in that courtroom of honest dependability, of something being fair and just.
You mean other than a dog and a pony show?
Yes. You know, they're getting a perspective on this thing that all this thing is. It's basically was a dog and pony show. It had nothing to do with justice. It had nothing to do with your rights. It had basically coming in and getting a paycheck for that day.
It would seem.
But, you know, like I said, with what is happening, with what is going on, I'm still hanging in here with what we're doing. Still hanging in here with this. I'm still fighting them. I have no guarantees that these people are going to be honorable on their side of this fence. I have no guarantees that they're going to be any type of integrity on their side of the fence. So this is something that, no, ladies and gentlemen, we have no way of enforcing anything on their side. We have no way of enforcing anything, and that is where the problem's coming in. And this is where you people need to come in, because in Washington, D.C., you can go to several different places. And that couple of these places are the Sergeant of Arms in the House and in the Senate. These are the offices that are in charge of the District of Columbia. The Sergeant of Arms, the Architect of the District of Columbia, and the DOJ Office of Responsibility, Professional Responsibility. These are three offices that you can go into and address and file a formal complaint of what is of misbehavior in D.C. This avenues that you people have. This goes right back in of what we've been sitting here teaching right here in North Carolina, is what the people here has been finding out, is that when they sued the police department, they were told that they had to go finally to the mayor in order to bring a charge against the police department. And the reason why is this, because if you look at this as a house, each of these departments is a room in the house. You can't go in and sue one room. You got to do the whole house. You can't fumigate one room because all the little cockroaches are going to go to all the other rooms. If you want to get rid of the cockroaches, you got to fumigate the whole house. And this is basically what they were sitting here saying. If you want to deal with this, you have to go to the mayor, because he is the executive officer of that community, and he is responsible for the police department or these agencies underneath him, because he is the chief executive officer and the head administrator. All right? Same thing with the state. You have to go after the governor and the attorney general. In the city, you go after the mayor and the legal advisor. But you also need to see if we can find their insurance company, because now we're going to bring an insurance claim. And you name that public office and its employee of that office in the claim. And that's what we're talking about on the state side. You go to the governor, you go to the attorney general's office, you go to risk management, and you bring in that state official in his physical capacity, because North Carolina has just made a ruling in the Supreme Court. The Supreme Court has now stated that we can sue the employees of North Carolina if we bring them in their physical capacity, not in their business capacity, not in their state capacity, but in their personal capacity. Bring them in under their name, and they now can be sued.
Well, that's a good decision, isn't it?
It is. Supreme Court in North Carolina just made that decision here. A couple callers have sent this over to me. So it is a good decision. But we have to bring them in. But again, whenever you're going to bring a suit against them, you need to file your interference in. You need to do like the lawyers do, bring in that interference into this thing. And then go after them with a formal complaint, with an affidavit, and then file it against them. But you bring in risk management, because risk management now is the insurance company. Once they start getting involved in this, now they start going back in and looking at their insurance policy and their bond, that if this becomes an issue, they're going to pull their bond on them. And once they pull their bond, they lose their job. These are some avenues. Then once you get a conviction administratively, now you got the claims court. Whether it's a claims court or small claims court, and from what the understanding has always been, is once you get them into that small claims court, you now can sue them, and again, in their flesh and blood capacity side of this for breach of their duty. But see, they can't have a lawyer walk into this claim court on their behalf. There's no lawyer. It's you and them in that courtroom.
Good luck on them trying to defend themselves against somebody like us who knows a thing or two.
That's exactly right, because these guys are not trained in the law. They're not educated in law. On the other hand, you and I, if we study, we can get this thing down pat, and they're going to have to go back and prove that they did not violate your rights whenever they did to you what they did to you. They're going to have to go back and prove they didn't violate the rights, and they can't. Because that's why they're in there, is because they didn't follow procedure. Did they have a complaint before they pulled you over? No. Did they have a warrant before they arrested you? No. Did they sit here and arrest you without any proper procedure? Yes, they did. Right there is their own rules and regulations that can come back in, and we can start bringing claims against them. And we can start hanging them. Because once you go in and you bring a claim against them, they now lost their bond and they lost their job. They no longer can hold a public office because now they become a risk. You know, am I trying to be nasty here? No, I'm not. I'm not trying to be nasty, but we're being forced to defend ourselves. We're being forced to use the system and go after them on this. And we're trying to go through proper means. We're trying to do this in very peaceful means here of doing accountability on them. And that's what this whole show has always been about, is coming back in, is doing accountability on these people. is what this show is all about, is to go back and do accountability, is to hold these people accountable for what their job is. Now, to get them to do their job right. And if asking them to do their job right makes us anti-American, and asking them to do their job right makes us anti-government, then we got a very serious issue here, because we're not the ones that swore an oath to the Constitution. We're not the ones that sit here and swore that we would protect the people's rights, we would preserve their rights, and we will accept wages and compensation to make sure that their rights are protected. We didn't do any of this. They did. They took the job. This comes down to falsifying a job application. This now comes down into perjury. You accepted wages based on fraud. This is no different than you going down to a barber and asking for a specific haircut and he gives you a butch. That isn't what I asked for, and that's not what I'm paying for. Or you getting your house painted and you wanted it painted blue and they turn around and paint it pink. That's not what you paid for. You now can sue that contractor for breach of contract. And that's what these people are doing. They're breaching a contract. But it's taken us a while to get educated, and it's taken us a while to understand this and how to start working on some of this stuff and how to come after it. It's taken us a while to learn.
But we're learning, aren't we?
Yes, we are. Yes, we are, because the attorney that I have up there, he says, Rod, you're right. What you're saying is correct. But inside that courtroom, no. If I am right outside this courtroom, then I'm right inside that courtroom. That has to be the same set of rules, inside and out. Because what it boils down to is this. We can start doing this with these law enforcement officers. And they come up and says, do you understand your rights? No. Well, what don't you understand? Well, obviously there is a misunderstanding between your understanding of the law and mine. And what you're saying here, how do I know when you're talking apples that you're actually talking fruit and not a computer? Because there is a language terminology difference between your understanding and mine, how do I know what you're saying is the truth? So you're asking me, do I understand? So I'm going to have to tell you, no, I do not understand. Until we get a clarification of verbal communication between you and I are on the same page, and you and I have the same understanding of what the law is and what we're talking about here, I can't really say, yes, I do understand, because at this point, I really don't know what you're saying. And that is something that you could turn around and use in a courtroom when a judge sits here and reads you your rights. Do you understand? No. What don't you understand? Well, first off, the law sits there and says the word person. I need a clarification of what the word person means. Because my understanding of the word person is a corporation, it's a trust, it's an association. It is a firm. It's a joint stock share. Would you please explain to me how that applies to me so I can understand? Because if I got to understand this, then I need to understand your language and terminology. And explain it to me what it means.
And what's in your books.
Exactly. Ladies and gentlemen, this comes down to about everything. And we got talking about foreclosures. All right, well, I talked to a couple people about foreclosures up there on this stuff. And the bottom line boils down to this. It's real simple. You all know about the Federal Reserve Act under Section 16. Federal Reserve notes is an obligation of the United States. It only goes back to the banks and those authorized representatives, which is not you and I. You're also aware of Title 12, 95, 95A, 95B. Everything is done under state of emergency. You are aware that the Federal Reserve note is not money, as McFadden sit here and stated on the floor of Congress that Federal Reserve note is not money but a mere promise to pay. The issue in a bankruptcy is not the fact that I know that, Your Honor, that's not my signature. No, Your Honor, I didn't sign it. It is, yes, Your Honor, that is my signature. I did sign that promissory note, and we're in here to find out why the bank did not take that promissory note down to the comptroller of currency and why they did not discharge the national debt. Whoops, what did you just sit here and say? We're asking why the bank did not take that promissory note down to the comptroller of currency and discharge the national debt. I gave him my signature. It was his obligation to take it down to the comptroller of currency and withdraw the money out of the account and discharge the national debt. Instead, he sold it to one of his banker buddies, at which point, selling it to a banker, he has now created a surety fraud against the state and against the government. And by selling that note, he has failed to pay the county taxes on that note, on that property, for every time he sold it. We are in here to discuss why they are not doing their job, and I want to remind this court of Title 31 of 3713 that lawyer is the trustee over that bank, and he is here to settle the account on behalf of his client, because he took the responsibility to walk into this courtroom instead of sending his client in here. So he now becomes liable for the public debt, not the bank. If we're not dealing with any money, then how can we be held accountable to pay something when there's nothing there to pay with? When the understanding is when we gave our signature, that signature was the collateral that was supposed to have been given to the comptroller to discharge the public debt. And it wasn't discharged. Simple logic, simple thinking about what we've learned here over the last several years. Real simple understanding on this stuff. I got a couple of people that want to come in and ask some questions. Let me bring them in here.
All right. Hey, Rod, I'm going to ask Debbie from Maine, if she's still on the call, to raise her hand. Press *8, Debbie. And
where's she at?
I don't know. She's from Maine. I don't know if she's still on the call, but she has a question about the Article 3 court and the Article 4 courts when you were discussing let me see if I can get to my notes here. Discussing constitutional issues, that the only constitutional courts is the one in D.C. and the one in Hawaii. When you were discussing that Section 88, whatever it was.
Yeah.
Yeah. So anyways, so if she can raise her hand by pressing *8, that would be good. So if you see her, after a bit, see if you can bring her in or whatever.
Yeah, let me start here at the top. Greg, go ahead, Greg. I'll bring you in. Greg? Hi. Greg? Are you sleeping on me?
Unmute yourself.
Hit your *6.
I muted myself for your own, I'm sorry. I muted myself in the beginning so you wouldn't get the background. I forgot. Can you hear me okay?
Yeah, go ahead.
Go ahead. So I was just going to throw a few things, what I would do, just some avenues, and you can discuss or not discuss why you would or wouldn't do it. But you got them. I mean, obviously you're making headway, but you know that you got to tell the judge what to do. You know that, right?
Yep.
Okay, because if you wait for them, they won't. They will no. You've got to tell them. Like if you want it dismissed, if you don't tell the judge what to do in court, they'll just keep scheduling hearings. What I would do, this is what I would do. You got this thing coming up in March. I would do a subpoena ducis tecum for number one, a B10 claim for a claim. They do not have a claim. You've said that over and over again. Number two, an answer from the damn prosecutor. Number 3, an order for the warrant. Any order. Now, we already know they ain't going to be able to answer any one of them. So when you get into your hearing, you make judicial notice of the judge's oath. The only question is going to be, Judge, has there been a return of the writ? And they'll try to dance around it. You ask them again. And if there hasn't been a return of the writ, then you tell them you want to dismiss, find under fact and law, and dismiss under 12b-6, failure to state a claim. Now, if that don't work, tell them to ask the judge, if they're going to schedule another hearing, that you want an appearance bond at no cost to you and to waive all fees. And I can actually send you a copy of them, and all you do is sign your name.
Okay.
Because remember, the banks, you're right about everything. I'm not disputing anything you're saying. But the problem what they're looking at, and you're talking about the banks, the court itself is a bank. Now, you said earlier, I know I saw your paperwork, but I don't remember seeing the word counterclaim.
This last one I put in.
Use the word counter. Okay.
The
counterclaim gives them an out. The counterclaim gives them an out to zero the books. But if you go in here with this subpoena, and look, I can talk to you later, and you can actually come up with a few more things, because the thing you want, they have to answer all of them. They can't come in and just answer one of them. And if they don't answer, that's a summary judgment, just pure and simple. And then if that don't go right, then what you want to do to hold them to their bond, to put a distress on bond, you want to have, I believe we just found out that's called a Data Integrity Board hearing. And that's where you're going to go through and sit in front of that Chief Justice and go through where they're just completely don't know what they're doing. You know what I mean?
Yeah.
And then you can take that and apply it to everything that you've been saying, you know.
Well,
I just wanted to say, you know, I'm trying to find a way to close for it, you know, to get this closed, because holy crap, Ron, this has been going on now, it's almost a year.
Well, it has, and this is what has got them frustrated, because, see, they're not used to someone coming in and dumping the paperwork in, because had I had not filed that end of appearance into this thing and start asking for that in-camera stuff and start expressing this stuff, and I've asked for a declaratory judgment a couple different times on this, and the prosecutor has not answered that last set of documents back in January. With the answer that he came back with was not.
I know you sent it to.
Yeah.
It wasn't. He didn't address anything. The guy was an idiot.
Well, this is it. This is why we went back and did a squash on him and a strike and on this, and then we asked for a declaratory judgment to have this case dismissed, because he did not sit here and produce anything that he was asked to do. And what the judge did sit here and say last Wednesday is she did say that there are several motions that is sitting before the court that she has not had a chance to read yet at this particular time. And these were these motions to go back in and rebut the prosecutor's response.
Yeah.
Well, I would go in with that subpoena duces tecum and booby trap them, because now there's not going to be any status, because the only thing that and you do this through the clerk, you don't have to go through the judge or anything. The only answer, the only conversation in that next hearing is going to be, has there been a return of the writ? And if they don't answer that subpoena with that answer, okay, which you can't seem to get, a B-10, a claim, because they don't have a claim. The only reason that you're wearing that ankle braces is because you pled not guilty. They got you in contempt of court. That's what they do to everybody. It's not guilty. They skip all the other stuff, and they work you on the not guilty plea because not guilty is contempt of court, and that's it. And that's what's wrong with our system. And so that's why if you go back in and you've done everything, I just don't know if, like I said, I don't remember seeing the word counterclaim in your paperwork. Answer with counterclaim. And that,
well, like I said, this one that I handed to them when I was up there, it was
okay.
It was another formal complaint under ultra-virus misbehavior with a counterclaim.
Okay, well that's what you didn't show me that. Okay, I didn't know about that. So that's good. Now they got to address that counterclaim, and they can take that counterclaim, and they can take you got a charge. It's a bank charge. It's like the cross. Jesus was on the cross, okay? The double entry bookkeeping system is you got a plus on one side of cross, and you got a minus on the one side of cross, and at the end of the day, at the bottom of the cross, it's got to say 0. So now what you've done is that charge that they're trying to collect off of your trust, with that counterclaim, they can zero. You've given them an opportunity to zero the books for the first time. But if you go in with that subpoena ducis tecum, and they answer it, it's over. And if it isn't over, you go in with a show cause and a data integrity board hearing, because it's no longer the judge telling the guy. Got to remember, the judge, the prosecutor, and your lawyer. It takes 3 signatures to put you in jail. The judge, the prosecutor, and your own lawyer. Now, I'm pretty sure you're not going to sign anything to sign yourself into jail.
Nope, that ain't going to happen.
So what I'm saying is that's why they keep wanting to dump the lawyer on you. So you're almost home here, and they definitely need to be called to task, because they have. When I read that guy answered to you, first of all, he not only did he not answer it, he lied in it. Your second arrest, you cannot tie your second arrest to the grand jury. They need to do this right. They need another grand jury because the first case was disposed.
Yep,
that's right.
So you're gone. It's done. When they told you, and this is a trick they do to everybody, brother. Well, the feds indict you. Come on, turn yourself in. What you done? What you should have done is say, "Come get me." You ain't never would have heard from them.
Well, I understand, but it's the problem of it is.
I know.
Yeah. Okay, I appreciate it, Greg. Let me move on here with what we're doing. And then
call me anytime, buddy. You know that.
I will. I appreciate it, Greg. Thank you.
Okay. All right. Bye-bye.
Bye-bye. Bye-bye. Maine. Go ahead, Maine. Hello, Debbie.
Yep, it's me. Hi, Rod.
Hi, honey. How you doing?
First of all, let me say God bless the fact that you're home and safe.
Yeah, my wife's definitely happy about that.
I bet she is. I bet she's one happy woman right about now. As you know, I'm in a foreclosure case, and I've been in it since 2009. And I have gone up through the main courts here, and they're rubber stamping one another, one right behind the other. And I even gave the Maine Supreme Court a second chance at rectifying their boo-boos by putting in a motion for reconsideration. And in my motion for consideration, I showed them their boo-boos, and I told them not only the state law violation questions that arose, but the federal ones too, so that they would understand that I was preparing not to go to the U.S. Supreme Court on appeal, which is where I'm supposed to go after the Maine State Supreme Court goes and goes against me. I told them in no uncertain terms that I was going to be raising constitutional and federal questions and bringing it to the U.S. District Court of Maine, because I want to be able to end up in the First Circuit Court, because they understand this foreclosure business and all the fraud that has been perpetuated upon us, and I have a real good chance in getting the twerp butts. But to get to the First Circuit, I have to get into the federal court system. So I get on to their website, and they have a whole section there for pro se litigants. And they even have a little handbook in PDF form that tells you, they say this is, of course, not an exhaustive, comprehensive guide to everything, but this is the main points that you need to know, and to be able to come into court. And among that, they do say, and hold on just for a minute because I got to get to this screen. In the pro se litigant handout, well, come on now. Alt tab, thank you. Come down here. It states, and of course because I want to see it right quick. Okay, it says the United States District Court for the District of Maine is a federal court. Federal courts only have jurisdiction or legal authority to hear certain types of cases. As in this case, as is the case, in all federal courts, this court is generally authorized to hear disputes that fall into the following four categories. And it's the first category that goes to where you are stating about Article 3 court and only being in D.C. and Hawaii. It says all federal courts can hear those that deal with a question involving the United States Constitution. The federal courts hear specific types of cases described in the U.S. Constitution or specifically provided for by Congress. So if that is the case, and all federal courts can do that, how is it that you all say that the court in D.C. and in Hawaii are the only ones that can hear constitutional?
All right, let me explain to you. I want you to go into Title 28, which is the Judicial Procedures, okay? There is a section in there that deals with the court system itself, where the courts were created. And under that section, as you start pulling it up, let me pull it up here. Title 28, USC. Judiciary. Okay. What we've discovered here is one of the listeners sent this to me as an organization of the courts. Under Chapter 5, District Court. All right. What it gets into in the District of Columbia is under Section 88. And it gets into the notes. So this section expressly makes the District of Columbia a judicial district of the United States. Section 41 of this title also makes the District of Columbia a judicial circuit of the United States. Under Section 11-305 of the District of Columbia Code of 1940 ED provided that the District Court of the United States for the District of Columbia shall pass the same powers and exercise the same jurisdiction as the District Court of the United States. So we went from the United States, the District Court of the United States for the District Court of Columbia, down to the lowercase. It shall deem to be a court of the United States. In constellation with the ruling of the Supreme Court under Donahue versus United States, and it goes in and explains the Supreme Court of the Appeals. But it goes in here and it tells you that the District Court in the District of Columbia is and has to operate as an Article III court. The same thing it says about Hawaii. It has to operate as an Article III court. But if you go down into Maine and you look up Maine, which is under Section 99, and you get into the footnotes, then it starts explaining to you that in the 1940s, when this thing was created, it was changed over. And it goes into it's basically a territorial court.
So it's not constitutional.
No, it's a territorial court. Now, it can hear constitutional issues, but it's a territorial court. And territorial court falls under that 1391. And that 1391 falls under foreign sovereign immunity. So they can hear constitutional issues. It's just that for what we have found, and that's why I told you people, I want you to go back in and get into Chapter 5 under Title 28. I want you to get in and look up your Pacific courts. Look up your Pacific court under this title. Sit down and see how it is classified, because some of these courts had their judicial power removed from them, which made them strictly administrative.
Oh, that's the point you were making.
Yes.
Oh. And so an administrative court couldn't hear anything constitutional, could it?
No, it can't.
Oh, okay. So Debbie, do you see where he's going with that?
Yeah, if the state of Maine is not the district court is a territorial court, which can hear it, but if it was an administrative court, it wouldn't be able to.
Exactly. So you've got to come back in and address this under the administrative procedural violations on what they're doing here.
Well, the thing is if they're a territorial court, then they're not violating anything, because territorial courts can hear constitutional issues.
Yes, they can.
But Debbie, you need to find out whether or not Maine was converted from a territorial court into an administrative court, right?
Yes.
Oh.
And how would I do that?
Go back in, get into the historical background under Chapter 5, under Section 99, and go read how they changed everything over on the historical revised notes.
And is that available online?
Yes, it is. All you got to do is punch it up and get into notes and read the historical side of this.
All right. Well, Debbie, you got your assignment. Debbie, by the way, is an excellent law writer. You ought to see her stuff that she puts into court. Unbelievable.
Well, this is what we need. We need more people who can write this kind of stuff up and come back in and address it correctly on these people.
Oh, yeah. She does a very good job. And I don't mean to be tooting her horn, but it's great. She does great stuff because she sends it to me all the time.
But you can also, what may be better is that if you get into the United States Code PDF annotated and pull the PDFs down on this thing. Just don't get into the Cornell Law side, but because there is a section that you can push in United States Code PDFs. And they have all the annotated, and that would really be the better one that you could get into, because the annotated really goes into the fine detail, because the one on the internet that says Cornell, they could change and take some of this stuff off, and you'll never know it. But if you get the PDF, they can't.
So
Yeah.
that's,
Follow me?
Yes, I do.
Okay.
all right, well, you got your assignment, Debbie, anyway.
Yeah, I guess I'm just going to have to go visit Cornell again. Well, thank you so much, Rod. And again, I'm glad to hear that you're home, and keep giving them hell.
I am.
Okay, you have a good night.
Good night. Thank you.
Thank you.
But ladies and gentlemen, yeah, that was brought up here several shows ago. Get into Title 28, that Chapter 5. Get into the court of how they were created. Get into the historical side of this thing. Because it shows from the 1940s up to 1959, they changed them from the Article 3 to territorial. And as you go down through, and it starts showing you that they come under 1391. If you go back and read Title 28 under Section 1391, it falls back under foreign sovereign immunity. Now you got to go back in under the foreign sovereign immunity side under Title 28, 1602 to 1611, and you have to come in compliance with the foreign sovereign immunity side to bring a claim in. They've really got this thing a cluster. They really do.
Yeah, I guess so. But now, you did recommend that Debbie go and look at the U.S. Code PDFs, which are annotated, not Cornell specifically.
Yeah, get into the annotated, get into the PDFs, because Cornells, they have a tendency to change and leave things out. If you get into the PDFs annotated, it is the printed version, and it's a little bit longer, and it gives you more detail. But
I'm trying to remember, did you ever find that the PDF of the U.S. Code? I think you did. I'm going to have to look into my files and see if I can find that, and see if I can get, if indeed I've got it.
Well, if Debbie's got a Skype, I could send that file over to her on Skype. And under Skype, I run under lowercase AIB, a little period, radio, and it comes up Heischel. So if you punch in AIB, period, radio, get a hold of me on that, and I'll send you over that file on that so you can get into it and read it off the annotated side of this thing. But if Debbie, if you have not filed an enter of appearance into this thing, this is what we were talking about earlier. Get your enter of appearance in so the judge will recognize you. Because prior to me filing the enter of appearance in, when I filed that first complaint in with Judge Wilkins, he kicked it out because I did not ask permission to file. When I went in and asked for permission to file under enter of appearance, all my paperwork got accepted.
Right. But did Wilkins approve that, or did Kessler approve it? Kessler approved it.
Yes, Kessler approved it.
Right. This was after Wilkins was off the case, right?
Yep. But when we first did that test run, we tested it first.
Yeah.
And it got kicked back. Then I went back in and filed my enter of appearance in.
And then she approved it because she was on the case at that point.
Yep, she approved it because even though I had a public defender, she still approved my enter of appearance on that in-camera hearing on this thing.
I remember that, yeah.
So, ladies and gentlemen, this is very significant that we definitely go back in and we file an enter of appearance at what we're doing here.
Right, because, see, the lawyers don't have to technically, they're supposed to file an entry of appearance, but their bar card normally satisfies the court's requirements for an entry of appearance.
That's
right?
what they're sitting back and saying, but the reality of it is, under the rules and regulations on this thing, they have to file an enter of appearance in, and if they are going to leave a case, then they got to get permission to leave the case. They can't up and leave. They got to get permission, and whoever comes in afterwards and asks to come in now has to turn around and get permission. They just can't sit here and swap out people here because it's convenient.
So now, Rod, that gets into your prosecutor there in D.C. The first prosecutor is out of there, and this new prosecutor, Lallis, Lallas, do you think that Lallis filed an entry of appearance? Probably not.
No, he didn't, because it's not on the record. It has to be on the docket sheet.
But
and
now...
He's never filed it.
I know, but because the court accepts them, because they have their bar card, into the court to be able to plead cases and stuff, and, do stuff for the government, couldn't you technically get them on their black ink on white paper, which says they've got to file an entry of appearance?
Exactly. I can go back and do this. These are things that we can go back in and address. These are things that we can go back in and address.
And how do you think that they would address them? How do you think the judge would address that argument?
Well, that's going to be a very interesting question, because that's something that we need to add on that one document that you have up there for discovery.
Oh, okay. Oh, yeah, because you want to see their entry of appearance.
Yes.
Oh, yeah, okay, right.
We want to see their entry of appearance on this thing, because he had to have one. We want to see where the other one left, because he had to file a leave in order to get it.
Right. Okay. All right. We'll have to add that in there.
Yeah, he had to file a leave in order to get it, and he never did. So therefore, because he never filed a leave, he does not have permission to leave, and the other one doesn't have permission to get in.
No.
Again, ladies and gentlemen, this goes right back into their own rules, regulations, and procedures. Like I said, there's so much here to understand, but what we are dumping into these people is that they can't get around what they're doing. They cannot get around it. And under Title 29 CFR, Code of Federal Regulations, under Chapter 20, Occupation Safety and Hazard, under that 2200, Rules of Procedure, 2200, Rules of Procedure, and it comes in and it addresses their oath of office on interim appearance. It comes in. They have to file to get in. They have to file to get out. They got to get permission. They just can't say, well, I'm going to take another job position here, or we're going to swap positions. No. They didn't follow proper procedure.
And that means that your first public defender, Laura Quint, she probably didn't file for an exit from the case either.
No, she didn't. She just up and left.
They never follow their own rules. And
this is the devastation side of what we're talking about here, ladies and gentlemen. This is the devastation side of this, is that they're not following their own procedure, because number one, we don't know it, we're not addressing it, we're not bringing it up, and we need to on this.
Yeah, because remember, if you always argue procedure, it's just like if you're in real estate. Remember, you're going to sell a nice house, make sure it's in a good location.
Exactly.
Right? Always argue procedure. And because then that gives them their face-saving out for dismissing a case.
Exactly. You're allowing them an avenue to walk out of here with. You're allowing them that avenue to walk away.
Yeah. And that's very important. That's just a very important basic thing to learn. If you folks out there learn nothing else, just keep repeating to yourself, always follow procedure. Because they don't. I mean, they cut corners. They're cheaters. They're liars.
Yeah, because see, under Title 29 CFR 2200, Subpart B, Parties and Representatives. Under Section 2200.23, Appearance and Withdrawals. Appearance in first documents and pleadings. And the first document files on behalf of a party or intervener is signed by the representative. He shall be recognized as representing that party. No separate enter of appearance by him is necessary, provided the document contains the information requiring under Section 2200.6. Withdrawing counsel. Any counsel or representative of record desiring to withdraw his appearance or any other party designated to withdraw the appearance of counsel or representative of the record for him must file a motion for the commission or judge requiring leave, therefore showing that the prior notice of motion has been granted by him to his client or counsel or representative, as the case may be. The motion of counsel to withdraw may be in the designated of the commission or judges be denied where it is necessary to avoid undue delay for prejudice or the right of the party intervener. So they have to go back in. They have to file. It is not, well, okay, we're going to swap positions here. You take first base, I'm going to take second base. No.
See how fascinating this is. This is absolutely fascinating.
They got to get permission to go do all this.
And they never do, or they very seldom do.
Yeah, that's the whole point. Okay, 2200.6, record address. Every pleading on a document filed by any party or intervener. Now listen to what's being said here, ladies and gentlemen. Intervener, you and I are coming in as an intervener. Every pleading or document filed by any party or intervener shall contain the name, the current address, phone number of the representative, or if he has no representative, his own name, current address, and phone number. Any change in such information shall be communicated properly in writing to the judge or the executive secretary if no judge has been assigned, and to all parties and interveners. Ladies and gentlemen, this is what we've been missing. This is where you and I have to file that interference in. This is what has hurt us.
We're becoming the intervener when we're the defendant, and we want to intervene on our own behalf, correct?
Correct.
Right, and so we need to file that entry of appearance, and that is like wicked important.
Definitely. This is what has hurt us and what we've been missing out on. Here's the rules that sits there and says that if we're going to come in, because what they're doing, they suckered us into figuring we're going to represent ourselves. Well, you can represent yourself. And they don't tell you had to file an entry of appearance. Here's the law that says whoever enters into a case, you have to file an entry of appearance.
Is that black ink on white paper, Rod?
Yes, it is. It's under the Code of Federal Regulations.
Oh, that's black ink on white paper, yeah.
You got that right. This is what we've been missing, ladies and gentlemen. This is what has hurt us. This is why we've been getting hammered on some of this stuff.
Because we think we're filing in, we think they're reading our paperwork, and they ain't.
No, but see, this also comes under Rule 26, or Title 26 under the appendix, and Title 26 is IRS under Rule 24, and it goes in here and addresses the fact that you've got to file an interference in this thing. They got to file. Now, we got another problem here, because from what we have been told, they're trying to get away with this electronic filing.
Oh, yeah.
And Harvey and I talked about this electronic filing. This electronic filing comes into a very serious issue because under Rule 11, let me pull it up here.
This is Federal Rules of Civil Procedure or whatever. Right?
Yeah.
FRCP.
Yep. This goes back into the Federal Rules of Civil Procedure.
This is a good rule too, Rod. Because here's the thing, you need to be able to, when you go into D.C. for the 26th.
Yeah.
Why don't you go in and see if you can get the clerk to show you all of their filings, and she'll go, oh well, they're over on the computer. They did it electronically, and you're going to say, well, where is the paper? Where's the paper that they filed?
Yeah, because I want to see the file. I don't want the computer. I want to see the file.
Right.
Because
so go in and look in the file, and if in the file it has that /S/, which means they didn't sign it, they didn't actually put that paperwork in, did they?
No, they didn't. And this comes right back in under Rule 11. Signing pleadings, motions, and other papers representative to the court. Sanctions. Signature. Every pleading, written motion, or other papers must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresentative. The paper must state the signature's address, email, address, email address, and telephone number. Unless a rule of status specifies state otherwise, a pleading may not be verified or accompanied by an affidavit. The court must strike any unsigned papers unless the omission is promptly corrected after being called to the attorney or party's attention.
That's pretty specific.
So all this paperwork that you guys are getting with no signature, under Rule 11 under the Federal Rules of Civil Procedure, it flat out tells you that piece of paper ain't worth a piece of paper to wipe your butt with.
Gee, I wonder how D.C. is, the ones that are lurking from D.C., the interested parties that are keeping track of you, Rod. I wonder what they're saying to themselves right now. Ooh, gee. Oh, I don't know. I think we may have screwed up here.
And this is the whole point. This is what has got them so rattled with me on what we're doing, and that's why we're trying to get you people to do the same thing, is to be able to come in, know their rules, know their procedure, tear them apart in the paperwork, and this is why we come back in and file a formal complaint under ultra-virus misbehavior.
Yeah, that would qualify.
Yes, it would.
Yeah.
You're filing in a formal complaint. Excuse me, they're not following the rules. They're not following your own regulations. You're not following your procedures. So now we're making a formal complaint. You can put it under judicial notice. Judicial notice, formal complaint. So now you're letting this judge know, hey, your people are screwing up.
So where was the law school you went to, Rod?
Up there on the street corner, up there in D.C., where they had the Library of Congress.
Oh, is that right?
I went to the Library of Congress for education, and they kicked me out. But ladies and gentlemen, this is the significance of what this stuff is and what we're getting into and learning and teaching you guys on here. Like I said, there's so much information here, but we're trying to break it down, and I'm showing you exactly where this stuff is at for you to go back and read and say, holy crap. And especially with what we have on here for a number of people, we got, 176 people on here. 172 now. And I would almost imagine probably about 10 or 20 of these is probably federal. Not more listening to this. And they're going to go back and read their books, and they're going to do the research as we're sitting here talking about it, and they're going in, holy crap, this guy's right.
Maybe we should revise our paperwork. Ooh. And, I mean, here's the thing. They don't like to work, so they probably won't revise it.
No, they won't. Because as long as they got their attorney sitting here railroading it and the prosecutor's not doing anything about it, then the judge can't make any rules on it because nobody's bringing it up for the judge to make a ruling on it.
However, we do know how to object, don't we?
Yes, we do.
Like that.
All right, let me bring in Iowa. Hold on a minute. Iowa, go ahead. Iowa?
Yeah, Rod, I just wanted to say something real quick. You forgot to tell the people about Volume 7, Corpus, or American Jurisprudence, Section 4, where the attorneys are for the state, the court, and not the client.
Yep, okay, we got to go back in and we got to revise because of some of that American jurisprudence that we've downloaded, they have went back and changed some of this. And that's the same thing with that 63 American Jurisprudence 2D, that 247. You go back in and reread this, they have modified that to have a different meaning here. So we need to go back in and re-update some of our knowledge on some of this paperwork.
So you're saying that...
Where's that at? You have it, I mean, where they relocated at?
Okay, what they've done is they have reworded that section. They didn't reworded it, okay? So we've got to be careful. We need to go back in and get new update stuff Because under that 63 American jurisprudence, it's got into where they were trustees and all this other stuff. Well, now if you get into it, it deals with paychecks and it deals with compensation. They have totally taken it out and given it a different title and different name.
Okay, where would the listener find that? Where on the internet? Where would he start looking?
You have to go back and just pull up Corpus Juris Secundum and see if you can download a PDF on it. And see if you can get the new one, because I've come across it. Sometimes it's hard. They don't always give it to you. But I've come across some sites where they've sit here and said, this has now been changed over to this, and they have totally taken that text out off the line here. So we need to be careful. Like I said, this one, I'll get my hands on some American jurisprudence books. But what I've seen on the internet, on eBay, seen some for as cheap as $500-600 for a complete set. But normally they cost about $2,500 or more.
Good Lord.
But I understand what you're saying, that Corpus Juris Secundum, Volume 7, Section 4, goes in and explains that. And some of that is still true, but we just need to be watched. We need to watch, and we need to find the new versions of this stuff, because they have changed it. They have changed it on us.
Yeah, so now they're doing a unfair competition on us.
Yep. All right, thank you.
Yep.
Texas, Panhandle, go ahead.
Yeah, Rod.
Yes.
Did you see that where Guest 144 put that up on the board about George Washington signed that bill that proves that the federal courts have no real judicial powers? Section 8. That guy's smart. Did you see that?
No, I haven't. Because it's hard for me to keep track of what's going on the board. And I'm sitting here talking with what we're... But if we can go back and find it, have them repost it.
Well, yeah, that guy's smart. I mean, he come a long ways there. But, yeah, you should look at that.
Okay.
You know, because George Washington signed it and proved that the federal courts have no judicial power. They have nothing. They're nothing. They got, you know, when he signed that bill, he took away all their power.
All right.
You know, you should look into that.
All right. Well, I'll tell you what. Guess what? 44. Guess 144.
Yeah,
Or guess 44.
Yeah, guess 144.
All right.
He was up there. Make sure you check into that and see if that's not true, because I know that's true, because that guy's a smart guy.
Okay.
He's pretty smart on that. Okay. Thanks, Rod. Just thought I'd hit base with you.
I appreciate it. Thank you.
Yeah, no problem.
All right. Guess 4, you've got my Skype. If you've got it, send that over to me on Skype, or send it to Harvey, and Harvey will get it out to me. Because if that's the case, then that's the document that we can go back and show if it's never been altered or been repealed. Then this is something that we can really come back and hammer them on. But like I said, from Title 28. Under that Chapter 5 in 1940s is when they switched the courts over from the constitutional to territorial, and they took the judicial power off these people. I see George Washington signed a document removing all judicial power. We need that document. If you got a copy of the document, we need that document. And then we can run with that.
Section 8 of the Judiciary Act of 1789. Yeah, he says it's Section 8 of the 1789 Judiciary Act. Okay,
well then, we'll get into it. We'll look it up.
Yeah. We should check that out.
Yeah, because like I said, if that's the case, because what the Judiciary Act did, it created the court. It created the building. It just created the building. It created the office. That's the same thing. It created the office for the Attorney General, and it created the office for the U.S. Marshals. It never filled them, and only created the office. But yeah, we'll get into that. And we'll pull it up in the statutes at large and sit down and see where it is at, and get in, read that Section 8 and see if it did do that. then, ladies and gentlemen, we're sitting on congressional records now that has modified all this stuff, and that's exactly what we need. All right, let me bring in New York. New York, go ahead. New York?
How you doing?
Good.
Yeah, I actually attended your last court appearance.
Yes.
Yes. A few questions. I don't know if you're familiar with New York, how they do things here, but based on the entry of appearance, which I'm fully aware of, do I have to serve all parties involved? In my case, it's family court. Do I have to serve actually, just verify with me who do I have to serve, and can I serve them on my own? Just want to verify that. We had a conversation in the cafeteria about this in the federal court building, but I need to verify the proper procedure so that it's not my entry of appearance is not kicked back in my face.
Okay. Anytime you file paperwork in, regardless of what it is, one goes to the clerk of courts, and I got a rule of thumb. I put one to the clerk of courts, and I send one to the judge. So that's two. You have to serve the opposing party. Now, that opposing party is either the attorney that's representing his client, or you send it to the party that you're in dispute with.
Okay. They have an attorney representing, but the attorney, I've done this before where I've just served the chief clerk's office, and the judge, as well as the third party, which is the representation, the attorney themselves. When the court appearance happens, that attorney will state to the judge that, this is not proper procedure. There's not a proper service because their client was not served directly.
Okay, then go back in and serve their client, because technically, when you serve that attorney, because he is representing that client, you have served them.
Right. So that's what I want to do. I want to keep it that way. I don't see why I have to go through the whole song and dance and the difficulty of serving a fourth person who has a repeated history of refusing service. A process service will approach this person, this other party, and he will say, "I refuse service."
It still goes back in. If it comes back refused, it still goes into they were served because you sent it out and it came back. Now, if you know you've got the right address on this, you can send it out by certified mail, you can send it out by regular mail, or you can have the sheriff department, okay? Because some of this stuff, you can have the sheriff department go in and serve them, and they cannot refuse service off the sheriff department.
Right. And another thing, well, a few more things. Thank you for that. Another is that hasn't the sheriff themselves, the local police who got you in this mess, as well as the federal courts themselves with this ankle bracelet, isn't that a form of bill of attainder?
Yeah, it is, but it also goes back in. It's a violation of the Eighth Amendment of what they're doing here for, excessive and extreme, penalties here. Correct.
So excessive extreme penalties is under bill of attainder. Like there will be no bill of attainder will be exercised. That's a violation itself, and it wasn't in your paperwork, but I mean your paperwork is very solid and tight as it is. I'm experiencing the same thing where excessive harm, which is a bill of attainder. Where do I make my complaints in New York State? Do I make it do I make it in the initial court that the complaint is and the dispute is, or do I make it in a higher court, the appellate courts?
You can put it in the court that you are in, and then if you need to, if they refuse or don't want to deal with it, then you take it up for an appeal, because you can appeal at any time, okay?
Yeah, but these judges, they don't really follow the law. They have a discretionary viewpoint that you're nothing, and they dismiss appeals flat out without even reading the paperwork. Or maybe they do read the paperwork, but they have a tendency of dismissing appeals.
Okay, but let's go back in. up until this time period, now if you stop and think about what we're going to say here, up until this time period, when we filed an appeal in, we never filed an end of appearance in.
That's correct. That is correct.
So therefore, because we never filed an end of appearance in, they had a right to kick our paperwork out.
Right. The only one other concern of mine is that. Well, thank you for that. The entry of appearance is very important with the corpus delicti and the fruit of poison tree and the clean hands doctrine. With the problem I'm running into, which many people who are doing this, is the risk of your opposing party being exposed to this knowledge.
Well, that's the risk we run here with what we're doing, but we have two choices. We can either sit here and keep our mouth shut and not pursue it properly, or we can go back in. The thing of it is, majority of the people out here that we're dealing with don't want to know this stuff, okay? So you're at an advantage here because, number one, unless they're on the show with you on another, a lineup here from another person from New York, if they're listening and you're both getting the same education, then you're going to go head to head. But see, if you're dealing with a divorce on this, you can go back in and nail for breach of contract because one of the parties had to breach the agreement of the divorce. So instead of filing for divorce, you go back and file for breach. If you're dealing with child services and you're dealing with child support, this is where you come back in and you address the bankruptcy and you address the Social Security Act of 1905 to where the state is getting X amount of dollars for that child under that birth certificate name.
Correct.
You bring up the fact that there is no money because there is nothing but a credit line here. And in the previous calls I've made here, I gave you some case law of the state being a third party. So now they have to come in as a third party into this thing as a, what the hell is that word? Indispensable party.
Indispensable parties, yes.
They got to come in as an indispensable party because they are a third party to this. So now Correct. They have to be drug in. So now you got to bring in the governor and the attorney general into this because they are the ones who has accepted that federal grant money under the Social Security Act in order to pay for that child and in order to pay for you because even though you're an adult, you're still under that Social Security Act because you still haven't been paid.
Oh, correct. That's correct. And you know what? Also, like the previous caller mentioned, the one who had who gave you some detailed advice of how to end your matter succinctly, he gave some good advice, which I do, is state declaratory demands or declaratory orders that you want the court or the judge to exercise and execute. For instance, the indispensable parties. In this case, my demand and my order was for them to pay their full share and retroactive funds as well. Correct?
Correct.
Okay. And on the other side, as far as the custody issue, the demand or order custody or joint custody or whatever immediately. Or if they don't want to do immediate joint custody, then automatic emancipation.
You've got some avenues here that you could go back and play with on this. Like I said, you go back in and you nail them under the bankruptcy side. And see, this is something that these courts, they do not want us to come in under the bankruptcy because once we start exposing this, and we start showing responsibility on their side of the fence that they have an obligation here on this, and they don't want to take it because they don't want us bringing it up. That's why we got to push it.
Correct.
And the fact that the son carries your last name or your daughter carries your last name, that child now belongs to you on this because the mother, even though the mother is the wife and the mother of the child, she had to take your last name.
Correct. We were actually never married, and she did a fast one and broke the law by attempting to change the child's my last name was attached to the child originally, and she made an attempt, a fast one, in a different court, civil court of name change, to change the last name without my consent, where she violated in their own rules various articles of notice, articles of not notifying me about that as well, which I got her on.
Again, like I said, you got some avenues here. You got her for breach, and you really need to go after breach on this side of it.
Right, breach of contract. That's I actually have stated that. I just need case law that would state that in breach of contract, where it doesn't, where the case law will support my argument. Does not have the marriage issue, because we were not officially state married. So she has some, so that, you know, they had some nerve to drag me in here when we're not officially married, but we do share one common child together.
Well, yeah, now you're getting into another field here to where there is no legitimacy between you and her, and you've got a child here between you.
Correct.
And because she's got possession of the child.
Correct.
This goes into whoever has 9/10 own possession here. But again,
correct,
your
right.
argument would go back under the bankruptcy side of that child's birth certificate being registered to the state, to where the state is receiving federal grant money.
Mm-hmm.
They are a third party into this, so they now have liability and responsibility to pay here.
Correct. Well, yeah, that's true. That's true. Now, when it comes to these corrupt lawyers who worked on her case, you listed, and I have a grocery list of violations where I can charge her attorneys for dirty hands and for misleading the court in order to get what she needs to get to the state where she's actually has custody. But what court, if it's not the direct court, a family court, what court can I prosecute their attorneys and perhaps the judges? Is that an appellate court, or is that, once again, is that the original court and then it gets moved up?
What you can do, if you can bring, you need to go back in and bring a claim into the court where you're at. And this is what I did for my son-in-law. I went back and showed where no lawyer can walk into the courtroom and represent John Q. Public. Okay?
Correct.
I went back and showed he can only represent a ward of the state. To go back and make your girlfriend a ward of the state. And you're coming in as the flesh and blood side. Now, because once you go back and name her as a ward, now she becomes incompetent.
Okay. And that's a separate claim that's a separate total claim from the claim of demanding a robust joint custody, and that's a separate claim from the child support issue. That would be the third. That would be the third segment of paperwork I would enter into doc. Correct?
Yeah, you go back and enter that right in. That's whenever this case come up with my son-in-law, that was the first document that I filed in. I went back in and I sit down and showed that his ex-wife was a ward of the state, and therefore she had to be represented by an attorney. Therefore, she was incompetent. And the fact that he was coming in as the living soul on this thing, and the fact that under the state laws, the Bar Association is either an agency to the state, which can only represent state employees, or it is a corporation to the state, which only can represent employees of the corporation. And as she was not an employee...
Right, she's not an employee. She's not getting wages, benefits, or compensation.
Yeah, so what we did is this pretty much slammed the court case that a lawyer can't walk into a courtroom.
Did the lawyer... Did the judge admonish or censor the lawyer, or what was the outcome of that?
The outcome was, when we filed this paperwork in, the lawyer never showed up, and neither did his ex-wife. He walked into the courtroom with me, and his name was called, and says, "Do you have a lawyer?" He says, "No, my father-in-law's here." I said, "Who's your father-in-law?" So he told him. He says, "Mr. Klaus, do you have a North Carolina bar card?" He says, "No, sir. What I do have is a congressional document says I am a private attorney general through the United States Congress. I don't have to have a bar card." He says, "Well, we're not going to allow you to practice today." And he called my son-in-law up. He says, you have contempt charges against you, and you have other charges. And what we're going to do, we're going to dismiss all these charges against you today. And if your wife can find another attorney that will come in here, then we will address this at another date. She has yet to be able to find a law firm that will take her case, because I went in and showed where no lawyer can walk into a courtroom on behalf of John Q. Public.
Correct. No, can I make it? That's fantastic. That's excellent. That's excellent tactical skills. Can I make a request that you upload a generic template of that on your Dropbox? Because I didn't see that in any of the documentation that would have that.
I will send that out privately to you if you send me an email. Okay,
correct. Okay, well, that's good. I'm the one that came in a little bit later on from New York.
Okay.
You know.
But put it line, just put in your subject line, son-in-law, and I'll send that over to you.
Okay, great. And another request is, since we live in a surveillance compromised state where they're eavesdropping on cell phones and landlines and also email accounts, I don't know how ambitious Team Rod is or your support staff, but I can volunteer my services and have a host, an out-of-country host server that can provide up to several hundred email accounts in one server domain. Anyone can volunteer to be part of that email account where it's outside of the United States, and they can log in and have a shadow or an alternate email when it comes to correspondence with you. As far as the phone in, that's a whole different story.
Also, if you've got a Skype account, you got a Skype account?
Yes, I do.
All right, send me something over on Skype. That would probably be easier under AIB radio, all lowercase, and I can send you that file over to you.
Okay, I'll try doing that. But right now, the current thing is my email account. I'll send it over my email because of my server, domain name server, and my hosting service is out of the country, in Canada, and I've also one in Brazil. So, as far as emails, it's concerning. But you get emails from all over the country, all over the world, and you never know what surveillance apparatus might be checking up on them.
Yeah, I definitely understand that. You can get with Harvey on something to see if Harvey would be interested in this, and like I said, we could talk about this.
Yes, especially when it comes into the calls. Not the calls, but any email that may come through. I don't know. It's just a shot in the dark. It's only a suggestion. Because we were, while I was physically there in D.C. with you, we of a few particular partners, a few particular devotees, and those aspiring to be private attorney generals discussed this matter as well. But I really appreciate your phone call, and I'll definitely write in the subject line in order to get that paperwork. And by the way, if you want to, at the risk of privacy, protecting the privacy of your family, you can delete or omit any names and dates that you don't want to disclose.
Okay, that sounds good.
Yes, and one other thing, all of your Dropbox documents, I actually consolidated them into folders, and then uploaded them again and shared them and emailed them to you. There's several different folders. So that Dropbox is very current and consolidated in folders for each particular documentation that you've done, the whole entire history of it, into I think 15 or 18 folders. And then I emailed it to you.
All right, well, caller, would you email me that information so I can go and take a look at it?
Okay, yeah, sure.
Mine is mentor2@gmail.com.
Oh, yeah, that's another issue. I totally thank you for telling me that. Mentor2
at Gmail. Yeah, MENTOR 2, the number 2.
Right. And once people become aware and become full in knowledge, they might want to think about an alternate email service besides the traditional Gmail, Hotmail, Yahoo, or Mac, or whatever they might be using. Or even Skype, because it's getting hot and heavy, and the powers that be are not liking what's going on, and the bankers and the lawyers and then the bar association and the judges. That's to me is the trifecta of our biggest hindrance in getting full remedy and peace of mind and also liberty. That's the full that they're the ones that we have to get rid of or put in check. So it's mentor2@gmail.com.
Yeah, I just joined unseen.is over in Iceland.
Oh yeah, I heard about that. Unseen.
Yeah.
SEEN. Yeah, right. Unseen SEEN, right?
Yeah, SEEN. UNSEEN.is, which is Iceland's
right,
domain.
Right.
Yeah.
Even there's a good one in Denmark too. A friend of mine, they've been listening to Rod, and they're sort of like an international fan club being
really.
Yeah. In Denmark, and particularly Amsterdam area, and also in England as well, and also in oh my God, they just had the craziness in Barcelona.
So
these people are listening to
national listeners listening to me.
Oh yeah, I actually emailed them like many years ago when I first heard about you through Joe Barton.
Oh.
Those people up there, their thing. So so one other thing is this last thing is that I appreciate what you guys are doing. Karen Hudds or Karen Hudds from the World Bank.
Yeah.
Her last name is Hudds or Hughes?
No, it's
Huddes. I think it's Hughes. I'm not sure.
Yeah.
Right. She is in a very, very unique position in this grand chessboard of seeking full sovereignty and remedy in all our court cases in our status, and meaning that I believe she's still in some type of shock, and because she really thinks that in a very noble way that those members of the Bar Association, international as well, will have a change of heart and come around and to help solve this problem. And I think that's a very gullible, naive way of thinking. I don't think the members of the Bar Association, the high members of the Bar Association, or the judges, or even international judges and lawyers, for that matter, are interested in letting go of that power, because they're part of the problem with the bankers as well.
Oh,
but
yeah.
she's in a very unique situation, and I would just have to make a note that she should not be so naive and thinking so positively that things will get better in a very cookie cut way. It's going to be messy.
Yeah. Yeah.
Well,
I agree with you, caller.
The thing of it is, where she's got her downfall is when we had her on her show, and I talked to her privately, and she went to Yale University.
Right.
And she was never taught law. And there's a lot of things that we talked about. I told her, be very careful, because you're running down some of the patriot side of this stuff, that it sounds good, but when it comes right down to the documentation, that documentation is not there to back and support what they're sitting here telling you.
That's true. Yeah, that's right. That is right. And see where she's coming from. She's coming from a serious, I would call it an academic handicap. And she's handicapped, and her thought patterns and her thought process are in a linear fashion. Our work that we're doing now, even Janine talks about this, is metaphysical. It's spiritual. No matter what denomination you are, no matter what religious sect you are, you could be Christian, Jewish, or Muslim. It's that as well as fighting and knowing the legal procedures as well. Excuse me.
This is part of the problem here. So a lot of these people, and this is what I ran into talking with the lawyers that I had, they're taught theories, concepts of law. They never were taught the law itself.
Correct.
This is where the problem's coming in with these people, is that they technically were not taught this stuff, but they can't go back and claim ignorance as they're operating in the courtroom, because when you bring it up to them, they'll sit here and tell you, well, yeah, we do understand this, but we don't operate this way. Wait a minute. Yes, you do. You have to operate this way, because once you start bringing in the intent of that law, and if you go back and read what they're filing on you, the basic statute is very vague and unclear. But when you get into the footnotes and you start understanding the footnotes, and it goes into the intent. See, that's like that Title 18, 921. It goes in. You can't have starter guns. You can't have this. You can't have that. But if you look at it, it gets into a starter gun is a smooth bore gun like a shotgun.
Correct.
And you can put a shotgun shell inside of a starter gun.
Oh, that's true. Yeah, that's right.
All right, and the thing of it is, when you get down into the footnotes and it gets into modification of the law, then it sits there and tells you, okay, this is to be construed under the understanding of the National Firearms Act of 1934, Section A, which deals with the sawed-off shotgun, the automatic, and the silencer side of this thing. So they don't want to get down into the intent, and that's where we have to get into these courts. We have to get down into the intent of this stuff. And this is where we are going to start handing them everything that they don't want handed to them, because now we are bringing in the true definition and the true intent of that law and how it's supposed to be interpreted.
Correct.
And that's the problem with them.
And their deliberate ignorance, and their willful ignorance is a violation in itself.
Yes, it is.
Title 18 under 13 to 46, Title 31 under finance of false claims 37 to 29, Title 18 under 1621 perjury, Title 18 under 1918 disloyalty. But one other, you mentioned the criminal code, Title 18 196. 1964. How does that play in, and how effective is that?
Well, it does. It comes back that you get into the RICO side of that on the Title 18, 1964. That comes back into RICO racketeering.
Okay, that's right. Okay, right. Good. Yeah.
And once you start getting
close union shop.
Yeah, because these people, they're trained in the law, they're educated in the law. Because if you ask anybody, well, go talk to an attorney, they can give you legal advice. Okay, now what this runs into is they cannot claim ignorance and lack of knowledge on their side of the fence because they're trained.
Right, and in the paperwork of all my actions in my paperwork, I definitely will state the violations that the actual individual attorneys. I'll list them by names and call out names and list these violations, which I just read off to you. How would I list the violation of their? Well, let me just rephrase that and try to confirm something. Did they also violate the American jurisprudence too?
Yes, they did, because under
63C2D.
But see, they also violated their bar oath, because under their bar oath, they stood here and swore that they would not mislead, misrepresent, misconstrue, and put false information before the court.
And is that under judicial rules of canon?
Yes, it is.
Okay. Okay, good. Okay, I'm there, getting there. I'm getting. You know what? I'm getting up to speed. I have a bizarre background, educational background, so I'm pretty fast learner. And once I have the verbal discourse and history behind it, and completely practice and rehearse the verbal discourse, that gives me the confidence as well to be up there on my own and cite all these violations, cite all the statutes at large, and go in there and just knock it out of the box right in front of the judge.
Well, and that's what we have to do. We got to come back in and show their own canon rules procedure. We got to go back and show their own professional ethics violation. On all this stuff, we got to come back and show that even under their prescription as a lawyer, there was no legislative law that created the lawyer. The only thing that was created through legislation was an attorney, and that attorney only works for the Attorney General's office.
Attorney General's office, right? That's correct. And it does not hurt to actually put into action that you demand full disclosure.
Exactly.
You're good, right? Well, that's the important thing of it all. Now, when it comes to this is one issue I have to take care of and address. The one is the IRS and student loan. Which is a second issue. If you have some patience with me, it'll be very brief, about 5 minutes or so. I actually did an accepted for value and other legal documentations and sent it to the Attorney General's office, Eric Holder, for my student loan, as well as the bank that issued it. They sat tight on it for a while. I didn't hear a response for 2 years. Then all of a sudden they pretended they didn't receive the paperwork, and now they have another collection agency that they retained. And I told the collection agency over the phone, I've already filed my accepted for value. I've already requested the Attorney General to discharge this debt through the Social Security Act, which receives federal funding on behalf of my name. I don't know why you're calling me now, and we are revisiting this case again. And I said to them over the phone, I'm not entering any verbal contracts with you. I'm not going to ask you to send me anything to start a payment plan. I want this student loan discharged. So I'm in a situation where you have any suggestions about that?
Yeah, it goes back into it. This is where my wife was wonderful because, see, her and I was at odds with one another because she was a bill collector.
Wow.
And when you are a bill collector, you buy the debt off of the person that's selling it, whether it's the hospital, whether it's the credit card, whether it's the jewelry store. You buy that debt. Okay, now it comes in to you now got to go back in and ask these people, okay, I want a verified claim from you that shows that I have a contract with you.
Wow, okay, I didn't know that. That's good information.
If I don't have a contract with you, then you can't bill me because there's no such contract. And if you bought the debt under the Fair Debt Collection procedure side of this, once you bought this under the bankruptcy, you paid for it.
So it's out of my hands. They're just looking to collect federal debt notes.
Yeah, so all these people have to do, you can't do it. Now all these people have to do is go back and file 1099-C, and then they could turn around and cancel the debt, and they can get paid.
And they file a 1099-C with the IRS.
Yes.
They're not doing their job. They're not doing their due diligence. Okay, I see what you're saying. And then you just notify. Well, if I get a call from the bill collector or the collection agency. You request to verify having a contract with agreement with them. Yes. Okay. Yeah, what my approach was, correct me if I'm wrong, was to resend in stronger language, and also based on my redemption, I have a redemption manual, which is about maybe, I don't know, 100, almost 150 page, which I'm going to share with everybody, which has verbal language and PDF templates and how to discharge your debt and accept it for value and to collapse your trust and to reclaim your trust. I was going to send that all over again, the student loan coupon, the so-called student loan statement, where it combines the principal and outrageous interest rate and processing fees, and resend it to Eric Holder and also the Treasury Department and the IRS again, just so they understand where I'm coming from and so they can discharge the debt. But you're saying that that's not necessary.
Well, this is the whole thing. We got to go back in because, like I said, my wife used to work for a collection agency. So basically, she was out here calling people to collect, and I was telling people to tell my wife to go screw herself.
Okay. There's something else.
Yeah.
Yeah. So that can be stressful. That can be stressful for her. That's like nervous wreck right there.
Yeah. So, but she sat down and told me is the fact that whenever she was in the debt collection, is that agency actually bought the debt for pennies on the dollar. So once they bought it, then it was already paid off. Okay.
Mm-hmm.
So once they paid it off, then that responsibility is no longer on your side of the fence. See, that goes right back into these mortgages. All right. Once that bank sells that mortgage to another bank, that mortgage now became paid off. If
right.
you think about this on the logical side of this, where this comes in at and how it works is this. Let's sit here and say that you've got a car and you got a title to that car and you still owe money on it yet, right?
Correct.
Before you can sell that car, doesn't that title have to be satisfied and that lien taken off of it before it can be sold?
I would imagine so. Yes, I would imagine so.
All right. So once you satisfy that lien, now the bank will give you the title so you can sell the car because they'll turn that title over to the other party.
Correct.
Now think of this in the mortgage setup. If they're going to sell that note to another party, that other party has to buy that note. And when they buy that note, did they not pay off that house again?
Right. They paid her. They seem like they're not only double, what's it called, double dipping or double down. They actually triple, quadruple downing on the same promissory note.
Yes.
Actually, multiple actions, multiple transactions.
So this is what's coming up with. This goes back in because every time they sell that note, someone's paying it off.
Right. I think
that house has been paid, but the problem of it is it was paid off with the original promissory note. But it's like we were sitting here talking. When you signed that note, that bank was required to take it to the comptroller of currency to discharge that debt through the trust that the government got for the state, that the governor got for the state for your birth certificate. He was required to discharge it, and he wasn't. So he created a public debt.
That's correct. That's
the same thing with their student loan. It goes right back in. They have to take it to the comptroller of currency or the IRS and just have them do a 1099 on it. You can't do the 1099.
I can't do it tonight. No, there's parts of some type of in some UCC booklets and accepted for value. They suggest they're using 1099, but I didn't bother doing that because a lot of people have gone being incarcerated with that, threatened with incarceration using that type of procedure. And we don't need any more people following you to face that jeopardy. Yeah, so I thank you for that.
Yeah, because see what they're doing, they're filling it out, and that is for the loan company to fill out for them to discharge the debt in order for them to get paid for the item. And people are putting their name down, and they're doing it wrong.
Right. So it should be. I guess this goes under a courtesy call, a courtesy notice to these parties, a courtesy notice for them to remind them that they should exercise that 1090 to discharge the debt.
Exactly.
Okay, great. Yeah, and it doesn't hurt to put in USC Title 31, USC 3713, priority of the government claims a person indebted to the government is insolvent.
That's exactly right. So
okay.
You got to go back and notify them of this, but basically what you're coming back in and telling them is that you don't have a contract with them. There is no contract here between us.
Correct. There's no contract. And just another option when it comes to these student loans and these mortgages on the promissory note, is it in my I can exercise is it within my right to send to the comptroller of currency these promissory notes with a request statement to discharge it?
Again, you're not the creditor in this thing. It has to come back from the credit card company or the student loan company in order to do this. Because I got into this with some people who deal with trust. Okay. And I asked them a real simple question, and the question was, if you have a trust set up for you are the beneficiary, the administrator, and the executor of that trust. Can your child come in and off that?
Right.
And the answer is no. Your child can't, because that trust is there for their benefit. They can't write nothing off of it. And see, that's where we're getting into trouble. We're trying to come in and write a check to discharge off our own account, when it should be the public official side or the company that we're dealing with who should be using the 1099 and writing this out and discharging it on their site. We can't discharge. We don't have the authority. I
see, and then that's another. Again, that goes back to a full, very informative, very robust instructions and a courtesy notice to these collection agencies and to these parties, where you outline the procedure and you educate them on how to discharge the debt, and for them to stop harassing harassing us.
Well, again, this is where we have to come back in with education on our side and learn how to address this and start filing paperwork in.
Correct.
You know, because what we're doing here, it has not been done. It has not been done the way we're talking. This is something I have started, but we are backing everything up with black ink, white paper. We're backing up with congressional records. We're backing up with their own documentation of how they're supposed to be doing it. And this is where the problems come, because the lawyers never bring it up, and nobody on our side has ever been teaching this stuff.
That's correct. That's true. That's right too. Now you mentioned the whole trust account and the Sistergate Trust. And, I mean, that's a whole another. That's a whole another. I guess campaign of trying to tap in. Where you mentioned that we're not able to actually tap into our Sistergate Trust because it wasn't set up for us. It was set up for them to take money out of us on our behalf because of the indispensable parties, where the federal government gave federal grant money to the states on behalf of every live birth through the Social Security Act.
That's exactly right. Because see, people are, well, if that's my trust, I can write a check off of. No, it was set up for them to discharge on our behalf, and they're not doing their job. And this is where the lawyers and stuff, where they have finagled the wording in this stuff, have railroaded us, and that's why we got to come back in under their own statutory law and push these issues on them, that it is their job, and that's where that Title 31 comes in, that 3713.
Mm-hmm.
Representative is the trustee over that trust.
Right. The priority of the government claims the person indebted to the government is insolvent, among other things. If no money to pay any debt, then the government shall pay that debt.
Exactly, but you got to remember something here, and this is what some of the people are forgetting, is the fact that these lawyers are a party to the bankruptcy. So now they've got an interest in this because they are a party to it. And that's part of what we are forgetting, is that they are a party to this.
And is that also the reason they're resisting this?
Yes.
Of course, that's the reason. Of course, it's a very obvious question, I guess. That's the reason why they're resisting us as individuals having this remedy to discharge the debt.
Yeah, because once it comes down to where they are recognized as a party to this, and they are, now it comes down to liability on their side, that they are not discharging their duties properly, and they now can be charged under the Lieber Code for treason.
That was it. Okay, that was the Lieber Code. So we remind them that they're a party to this, and then is there any law or statutes that claim that they are a party to this that can formulate into a written statement as well as the Lieber Code?
Well, it goes right back to what I just told you, Title 31, that 3713. Go back and read it.
Oh yeah, got it. The full run. Yep, I have it. And how you spell Lieber code?
It's Lieber code. Look up General Order 100.
Perfect. Okay. Well, just like you were just like, well, a final note, like you were, well, just like North Carolina was shut down and they're recognized as being private entities. This has to be that law. I mean that ruling in that level has to be done state by state.
It does, but what we got here, because it's an administrative ruling, it goes across the board. Because see, we're dealing with the Highway Safety Act and with federal funding under that Clearfield Trust side of this thing.
Right. Because any type of federal funding is affected. It doesn't matter what it is. It could be agricultural, education, highway funding. Right, correct. Okay, right. It's just that the New York State is not recognizing it as they should be. They want to put you in debt camps, debt incarceration for for alimony payments not being paid, child support, even bar and liquor license tax, commercial tax, unpaid DWI tickets, unpaid traffic tickets. It's gotten to a point where it's become it's the New York City. Because I live in New York, especially New York City, it's become a conveyor belt of putting people in a threatening conveyor belt of putting people in an incarceration mode 24/7.
Okay, but now this goes back in, violates your state constitution, because the state constitution, and even it goes in and states that you cannot be placed in prison for debt.
Wow, okay. Every state has a constitution that says that.
Yeah, let me pull it up here. I got my North Carolina Constitution here, and it gets into some of this under debt. All right, imprisonment for debt. There shall be no imprisonment for debt in this state except in case of fraud.
Mm-hmm. Great. And I can look at my state constitution and find that myself. Would it be under any particular place?
Yes, it's always under Article 1. It's always in the first section of your Bill of Rights.
Okay, thank you. Well, I can talk to you for hours, but I know other people might be on the phone.
Yeah, they are. We got other people on there, but I appreciate you calling in, and I hope I answered your question on what we're dealing with here.
Oh, absolutely. Yeah, I do record it. I actually do my own little dictation and write things down verbatim. Yeah, so I really appreciate it. And God bless you, and God bless your wife and her supporting you. And I met her, and hopefully I'll be able to attend the next hearing again. And peace and blessings to you and your team.
I appreciate it. Thank you.
Take care.
Take care. All right. West, South Virginia.
Hey, Rod, how you doing?
Good.
Good. Just one question for you. You mentioned the comptroller of currency. What statutory code or statute could I reference to present to, let's say, a car, automobile dealership to if I go out and purchase a vehicle and I say, hey, look, I'm gonna buy this vehicle, take this promissory note down to the comptroller of currency to get paid. What statute could I give them or read for myself to justify me saying that to them? I mean, because I'm just not making that connection.
Okay, what this goes back into is how the Federal Reserve was created under the bankruptcy of 1933.
Okay.
Under the bankruptcy, when this happened, the comptroller of currency was the receiver for the bankruptcy.
Okay.
When comptroller of currency, they turned around and added the Federal Reserve side of this to also to be the receiver. So you got to get into the bankruptcy and get into the Federal Reserve information on this on how all this was done. So you got to get into Public Law 1, 48 Stat C1 under the statutes at large and get into the bankruptcy and start reading the bankruptcy law, how the United States was put under the state of emergency.
Okay. And then from that, reading that, like you said, I should be able to pretty much comprehend how to go about, again, presenting that to the Comptroller of Treasury of the state, not of the United States.
Because the state has their own of what they're doing. But see, the problem you're dealing with is this. You're going to go out here and talk to one of us who's don't have any clue, that's in business, that the only thing he knows is that he has something tangible and he wants something tangible in return. And the last thing that he wants is a promissory note for him to go down to the Comptroller of Currency and cash in.
Correct.
We got to educate these people out here at a higher level. And some of this stuff, even though what we're trying to do when we're dealing with John Q. Public out here, they are not taught any of this, okay? And that's where our problem's coming in. I would sit down and work with this on the issue. If we're going to be dealing with each other, we really need to try to be honest, and if you're going to go buy a car, go pay for it. Don't try the fancy paperwork of doing the promissory note at a car dealership, because the moment you try that, they're gonna tell you it ain't happening, and they're gonna repossess the car on you or not sell it to you.
Right.
We got to watch what we do here with this stuff. We can't use it on each other, okay? And that's some of the stuff that we're trying to do. We're trying to use it on each other, and we can't. A lot of this stuff goes back in what we're teaching deals with the government, because when you got the government come after you, they're the ones that's in charge of that trust, not the car dealership, the government.
Okay.
Okay.
Well, I mean, me and my wife, we tried to purchase an automobile not too long ago, President's Day, and when we were about to sign the paperwork and everything, I noticed every one of the paperwork it referred to motor vehicle. So I went through the contracts, and everywhere it had motor vehicle and vehicle, I scratched it out and put automobile. And then when we signed it, we signed all rights reserved. Don't you know they wouldn't sell us the vehicle because they didn't want us to either reserve our rights or they didn't want us to make the changes, on the motor vehicle and vehicle. And I pointed out to the general manager and the sales staff. I'm like, look, this is an automobile dealership, correct? And of course they agreed. And then I'm like, well, how is it that when it comes to the contract, an automobile somehow converts over to a motor vehicle? And they didn't have an answer for me.
What you did, you altered their contract here, and because you altered a written contract, that's where the issue comes in. But no, I understand what you did, and before you sign it, you have a right to go in and correct and alter. But because that contract was basically written by the government, this is how it's supposed to be defined. If it gets altered, then you got to cancel the thing. Again, this is where we got to come back and educate the people.
Okay. Well, I mean, if I can't alter that contract, so what should I do? Just go ahead and sign it? But they still wouldn't let me write all rights reserved on it.
Well, again, that's the problem here, because these people do not understand this stuff. They have a certain procedure on how they operate, and they cannot legally or lawfully allow it to be changed, because now it goes back and exposes their fraud.
Gotcha. Okay. That was my only, I guess, 2 questions, Rod.
All right, thank you.
All right.
Maine, go ahead. Maine? Debbie?
Yes, it's me again, Rod. Yes, I put in a notice of appearance. As a matter of fact, not only is that in the handbook, the Pro Se handbook that they give us, but they, after I filed my complaint, the magistrate judge ordered, and it was put into the file that I was to put in a notice of appearance, pro se notice of appearance, and they even sent me the form so that I could do it correctly.
Okay, that's good, but the thing what we need to do here, ladies and gentlemen, when we file an interest of appearance into our case, we need to make a separation between that all capital name as being a ward or trust or an estate to the government and that of the flesh and blood. It's because if we do not make that distinction between the two, then they're going to treat us as a ward of the state and keep us on the state side. That's why I don't ever use the word pro se, because if you understand the word pro se, that means you're representing yourself. You're representing that trust name, and we're not representing that trust name.
Mhm.
So we got to go back in and make that distinction between the trust that they're claiming and who we are.
Well, when I filled it out, I put my name directly as I always do, with the upper and lowercase letters, and that's how I signed it. And whenever I put in my caption, when I put something in, and of course you have to put in the top part of the caption there that it's the U.S. District Court, and da-da-da-da-da, I always put the upper and lowercase. When they send things to me, it's all in uppercase, but when I send it to them, it's all mixed. So I don't know if that helps any, but that.
Well, what you have to do is make the distinction in your paperwork of what you're doing here. If you're going to do that, when this term is used, this is how it is to be implied under your rules and regulations. And when this term is used, this is how it is to apply under your rules and regulations. This way you're making that distinction for them, and this way they cannot mix them.
Right.
All right, well, Rod and Debbie, Rod, like how you've been filing your paperwork in your D.C. case, USA versus your all-cap name, ward of the government, blah, 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 and then underneath it, then you have your name, Rodney-Dale, ;class, blah, 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 living man with a soul.
Yeah.
Right?
Yep. And what we're doing when we're naming the state, we're coming back in and naming a state as an unknown entity with no known address, because what I just read to you, is that anybody who comes in, they have to have their complete name, their address, their phone number, and where do you ever see the state ever putting any of this thing down?
Yeah, that's right. That's a good point.
So just wanted to let you know, because you said you didn't know whether or not I had done that, and yes, I had. It was, I do believe, the second or third thing that got filed. So, yeah, they got it. They know I'm coming in by myself, and the handbook actually gives you just about step-by-step directions on what to do and how to do it, and they even give you a blank form because I filed informa pauperis as well. So, they're really good at this, and they have really been on the ball with it so far. So,
okay.
Yeah, but Debbie, they're giving you half the information. Still.
Yeah, I have to. Well, they say right in that this is not an exhaustive, step-by-step thing. We're giving you just the general highlights of what you need to know to do it properly, but it is on your own onus to go and read our federal rules and local rules and familiar yourself with it, because you're representing yourself, and you got to do due diligence, just as if you had hired a lawyer, he would have to. So
that's
true.
True.
See, this is what you have to do, but there's something else, Harvey, on that one document. We need to come back in, and you need to ask, where did they exhaust their administrative remedies before they filed a complaint and drug you in? If you're coming back in and doing a counterclaim on them, That there comes back in. Where did they exhaust their administrative remedies before they come after you? That's why you bring the claim against them. They didn't exhaust their administrative remedies.
Yeah, you're right. So are you saying on these 2 documents we're working on now?
Yeah.
Oh, okay. All right. I'll put that on the bottom, and then you and I should probably talk on the phone.
Yeah.
Maybe about that.
Believe it or not, that's one of the questions they even ask on the complaint that I filled out. They asked, what have you done, to exhaust all possibility of, getting this corrected before you got here. So I showed them. I went to my local district court. I went to the Superior Court. I went to the Supreme Court. So now I'm after you. So, yes, this is really quite thorough. And
yeah, but the point I was making, Debbie, is they're telling you how to do it their way. They're not telling you that where Rod does his filings into D.C., where it's, USA versus Rodney Dale Class, all caps, war to the government, whatever, and then underneath it he's putting his actual human living name and style the way he does, Rodney dash,
right.
dash Dale, semicolon Class, and then qualifies who that entity is. A living man, with a soul, whatever. You see what I'm saying?
I understand that, but...
So if you added that to your paperwork, I don't know what would happen.
Yeah, I don't know what would happen either, but...
I don't know. I don't know if you want to try it or not. I mean, I know you're trying to get into the 1st District, but, I don't know.
First Circuit. But, if I have to get to the D.C. Arena, then I'll probably do that. But up until then, I'm just going to go with my upper and lower case name and just keep making that distinction whenever I fill out paperwork so that they'll see that I'm not copying what they're doing. And by the time I get before the judge and the jury, because I've asked for a jury, I think they're going to absolutely have no question whatsoever as to how I'm going to present my case. And they're either going to put the hammer down on me or they're going to let me go and do my thing.
All right, now, Debbie, let me go back in, because, see, part of that administrative remedy falls under the Administrative Procedure Act. And this is what we was teaching some time ago here is what we're talking about. And whenever you're going after them on this issue, and this same way with what we talked about, if the administrative side isn't going through the courts, the administrative side is going through the agencies. Did you go to the agency and ask for an administrative hearing to address the issue before the agency? Did you go to the governor? Did you go to the state? To the head honcho? These are what they're looking at for administrative remedies, not from court to court to court to court, but you're actually going back into that agency and you're asking for a hearing. Because, see, this is what we found out down here in North Carolina, is in order to exhaust your administrative remedy before you brought them into the court, did you go to the agency? Did you go to the head department? Did you try to get a hearing? Did you discuss this? What was the results? And this is part of where we're falling short. Administrative is going back to the agency, not to the court system.
I went to the governor, and the governor read it, and he's got the paperwork, and he never got back to me.
Okay, so now you can put in your paperwork. Part of my administrative remedy is that I did go to the governor, as he is the head executor of the state of these departments, and he has declined to answer me. So I have exhausted it by going to the executor office who is in charge. So now this gives me justification for going through the courts.
Mm-hmm.
Okay, as long as you did that, that's part of your remedies here.
Yeah.
Okay, sounds good.
Okay, thank you, Rod.
You're welcome, honey.
Bye.
Bye. Patriot 1, go ahead.
Hey, good evening, Rod and everyone. And Rod, thank you for spending so much time today. I really appreciate it. I could not type in the chat, so I wanted to mention at markstevens.net, MarkStevens, markstevens.net. He went to the city council of Scottsdale, Arizona, asking them where do they get jurisdiction? Where's the corpus delicti? And Mark always sticks to corpus delicti, and so do you, Rod. And you also mentioned that the mayor, if the municipality is going after you, you got to go after the mayor as Jimmy, Billy Bob, the mayor. You go after Billy Bob, not the mayor. And in your D.C. case, at any time, did they accuse you of being an employee subject to their administrative process? Because it seems to me, if I need an administrative remedy, I've got to somehow be within the administration. I have to be an employee. I can't get an administrative remedy if I'm an outsider. Am I making sense?
Yeah, you are. That's part of what we're bringing up, is they had to exhaust their administrative remedies. They had to bring me in before my head department here and have me reprimanded. Well, I got a problem here. I'm not an employee. Therefore, you did not exhaust your administrative remedies on me because I'm not an employee, and your statutes that you're bringing me in under are administrative code. Therefore, they don't apply to me.
Okay, well, that's where the confusion comes in. You're going before a judge that is not part of the park police that arrested you. They got to take you before their boss. But instead, they're taking you to a whole different place where they don't even belong.
Well, see, this is what we filed into. See, I filed into the Sergeant of Arms of the House and Senate. I filed into the architect. I filed into the Department of Justice, the professional ethics side of this thing, and nobody has answered. So I have addressed the administrative remedy side, and nobody's ever come back on this. So there's no proof that I am part of their society because they haven't addressed any of this.
But in the meantime, they still have you with a bracelet. They still have you with a list of all your personal possessions. They've infiltrated your body, your flesh and blood, and your home and your land without any authority whatsoever. And this judge has done this to you without even addressing. What I'm thinking is, am I an employee of this administration? Why have they brought me to you, Judge? Why aren't I in front of their boss? Because are they accusing me of being an employee? Why am I here? Why are you talking to me? Why haven't you pointed a gun at this liar and thief and put an end to my misery?
Because what has happened here up to this point? Up to this point, I played with a public defender, and I had, like I told you people a long time ago, I had to play with him in order to get him to commit the crime. I have filed for a enter of appearance for the in-camera hearing on this. I've got my enter of appearance in. I have filed for a release of this public defender, and right now they haven't released him. I went down for that psych evaluation, to which I passed it, because they come back and the psychiatrist sits down and says, Mr. Klaus is more than competent to handle his own case. He no longer needs an attorney. So now we got the paperwork in that formally releases the public defender in this thing, and Harvey and I are working on the paperwork right now to go back in and address again for the judge to release him so I can continue what we're doing. In the meantime, all the paperwork that we're dumping in is now exposing this that the prosecution is not answering.
So what the psychiatrist left out of his diagnosis is all Rod needs is honest and truthful discussion.
Exactly.
Not to be pirated by liars and thieves.
Exactly.
And so thank you, Rod. That's all I wanted to add. But I wanted to get that markstevens.net where he goes to the city council and says, "Who do you think you are?" Basically is what he's asking them. And they said, "Well, I read it in the book." Well, and I've read Alice in Wonderland too, and I kind of enjoyed it, but I'm not there.
Yep.
So, thank you, Rod.
All right, thank you. Al, go ahead.
Hey, Rod, this is Al.
Yeah.
You know, the government seems to think they have control over children, guns, firearms. However, government was created to protect man's rights and property. So how come you haven't made a claim for your property, giving them a picture of Exhibit A, B, C, and D, which I understand to be your rifle, your handgun, your axe, and your hatchet? Okay.
I have put it in, but up to this time period, I've been dealing with a public defender that I have been playing with. And I have recently, like I said, the last time we was in, a motion was put in to release him. All right, he's supposed to have been released.
Okay.
But because they put me under psychiatric evaluation, she just now got her report that I am more than competent, I am more than capable of handling my own case, and I don't need an attorney now. So now on the 26th, I ought to be able to walk in here and drop the hammer on these people. Because what I've done, and Harvey's got the paperwork up there, as soon as we get it filed, we'll put it out, is we have now exposed the entire fraud of the incompetency of all this that has went on in this courtroom.
Okay. Well, as long as you put in for your property, and don't call it a gun, don't call it a rifle, call it property, you can get your property back. And point across the room to the thieves that stole it right out of your cart.
Yep.
All right, big guy. I'm out of here. Thank you.
Thank you. Bye-bye. Yes, 198. Go ahead.
Oh, howdy. Yeah. What's up, dude? I had an arraignment, and I noticed that they had a name in all caps and a non-all caps both at the same time, both at 9 a.m., and then they didn't really act like there was anything separate. And I didn't notice that until recently.
All right, you got to go back in. If you're going to file paperwork in, all right, let me start out this way. How knowledgeable are you on doing paperwork?
Yeah, sorry, I just got shocked. I was a deer in the headlights there. Basically, I haven't filed anything in yet. I've only listened to you guys for about a week, so I'm, cramming and surrounded by paperwork and printing a lot of stuff out at the library. But basically, I was going to do the writ of quorum nobis and the enter of appearance and a whole host of things next week as I get more time. But I was almost going to write a letter to the DA and just give him like a rope to climb out of the hole and just kind of hold my cards kind of close, but at the same time give them a little bit of an idea of the shitstorm that's going to come down. I don't know what you would say about that.
Let me give you new people advice. And for those of you this is your first time around. This is your first rodeo.
Well, I mean, I always just signed on the dotted line, and I always drive fast. So I've always been in trouble with this sort of thing. And yeah. Go ahead.
Well, what I'm saying, your first rodeo is the fact that this is the first time you've really been on a call, and to use my paperwork that you're going to use here, you really have to be able to know the historical side in order to go after this.
Well, yeah, I've been printing out extensive stuff. I just don't have enough time to read it. I'm late to the game, and I've been going through your archives, so I understand the gist of what you're saying, walk and talk.
Okay.
And last time when I went into the arraignment, I was just so scared. I was just shaking. I was the only one because my name's at the end of the alphabet, and I was just shaking. And I had a whole list of things that I was like, must say. I starred them and circled them and like, make sure you don't leave the courtroom without saying this. And I let him just railroad me, and he ended up entering a plea on my behalf when I was just asking the prosecutor to show me a little bit of, cause of action, corpus delicti, and that I went in saying, at the time, I just said, before I crossed the bar, I said I'm specially appearing, I don't consent to his ad personam, jurisdiction, subject matter, all that. So I kind of did it okay, but I definitely didn't have it, I didn't have my wits with me. I was just, not even able to react. And he even asked me, this was for not giving them my ID, because I was kind of, just talking to the cop like he cared what I had to say. They pulled me out of my vehicle for not giving them my driver's license. The judge, he even asked me when he was yelling at me, in between threatening me with contempt for asking about jurisdiction needing to be addressed. He asked me, "What do you know what driving is?" And I didn't even have my wits about me to say, like, that's why I'm here. Anyways.
Well, this is it. The advice that I'm going to give the new people here, for right now, it would be better to pay a fine than get into this with them and not have the knowledge to argue this. Because all you're going to do is really get this judge upset with you, and you're going to get the DA upset with you.
He threatened me with contempt like 5 times just because I was objecting without letting him finish. But the catch-22 there was that he didn't let me speak at all. And you know how they just rush you through and they threaten you and all this. So it was I didn't have a chance. But they already changed judges, so I have a new judge. And this is like, they didn't even have anything. Everything's just so shoddy that I need to fight. The DA doesn't sign the paperwork. The information they gave me, what they call the information, is just doesn't look valid at all. I mean, there's so much wrong with it and also that I basically manifested this whole incident by just looking into this and then, getting in an altercation. So they have me for interference and failure to display my ID. So this is the one for me to fight. I kind of made up my mind to take a stand. I'm a little bit nervous, but I've also overcome that with I'm inundated with, support, just all the paperwork. So I feel like this is a time to fight. But, I feel pretty bad not trying a few of these arrows.
Well, do the best you can, but watch your ground of what you're walking on here so they don't burn you, okay?
Yeah, that's why I'm curious how I know, because I feel like they changed jurisdictions while I was in my arraignment. Is that possible? I mean, I even looked around, the prosecutor was kind of pacing behind me, and that was kind of weird. And when I asked who he was, the judge didn't allow me to get his name. And you'll have a different guy next time, the judge said. And so I'm curious how I know, when I go in there, how do I guess I will figure it out, because I'm smart enough to, sift through this, But just as far as administrative support, I feel like they already got me through that part, and now they're trying to put me in a different one. And so I'll go back through the records and figure out what happened. But, yeah, I guess I'm not asking a question.
Well, part of what we're running into, there is no one guaranteed thing in these courtrooms, okay? The corruption is corruption. Either the judge is going to be honorable or he's not. The one gentleman that I talked to here last week, a young kid out of Arizona, or a guy out of Arizona, New Mexico area, tried to use my paperwork, and it postponed the judge for a few days, and the judge threw it out. What the kid ended up doing was listening. He walked in with his birth certificate and handed it to the court. He said, "This is the defendant. This is who you want." And he walked out, and that ended his case, from what we heard. That ended his case on this deal. Because that's basically what they're after, is the birth certificate. But see, that goes right back into the terminology of words. You got to start challenging them on their terminology of legislative words here and start pushing that issue.
What do you mean it ended his case?
Go ahead.
What do you mean it ended his case?
In other words, when the prosecutor asked, "Your Honor, do you want me to put him under arrest?" and the judge looked at the prosecutor, there's no warrant for that man.
Oh, you're saying it worked
for the birth certificate name, but there was no warrant for the living man.
Oh, okay. So if you bring that in, that's like a get out of hot water card, because you can say, well, no, this is what you want. I mean, look, I do plan on doing this very carefully and being eloquent and making it easy for them to understand. Because if you just go in there and say all this stuff, even if you're right, they're gonna be so shocked that they won't know how to transition into your realm, your point of view. So you're gonna have to spell it out for them, right?
Like I said, in some cases this has worked. Okay. In some cases, it has worked. Now, there's no guarantee. We have not found one surefire shot across the board that works in every single case across the country. And that's part of our problem here. And this is one reason why I'm telling the new people on this stuff, if you do not know how, because I had a gentleman call me here last week. on a traffic issue. He could not walk, could not explain. He was new into this. I said, at this point, take the plea, learn this stuff, and then come back in and bring a claim against them into the administrative side and charge them administratively.
Well, but shouldn't I put enough into this case so that it could be? But I guess if you plead, yeah, I'm not gonna. I'm so against the plea thing because, like I said, this is it's interference with a peace officer and failure. I feel like if I got all the way through to a trial and I showed them with my intent to dredge up all these.
Let me make this easy for you. Don't take what I'm saying as an insult to you, because I had a gentleman that called me and we got talking, and I said, if you cannot talk any clearer to me, trying to get your point across to me, and you're not under pressure and I'm not a judge, how can you explain this to the judge and get your point across? And this is part of the problem. When you start stuttering, stammering, and you're not sure, it's better right now to bite your tongue and take the plea bargain than it is to go in there and try to go to head to head with these people. And when the judge starts asking you questions, what's it mean to drive, and you don't have an answer, or what's it mean to,
Well, literally, it was so hectic in there that it went like this. He was like, when I kept saying, no, I do not understand, yeah, I was faltering, but I was just trying to, it was like a kung fu samurai magic battle, and he was like raining thunder and lightning and all this. So basically it ended up being, he just started speaking slower because he was patronizing, like, oh, you don't understand, I'll just speak slower. Like, do you know what driving is? And
yes, Your Honor, I do know what it means. And under Title 49 of the United States Code and under Title 49 CFR, driving means I am being paid to be behind the wheel, and this puts me under commerce, and I have yet to receive a paycheck.
Yeah, I just responded with "do you," and it went back and forth. I didn't hold his feet to the fire. I didn't do anything. I thought that if I just kept pushing the fact that jurisdiction has been raised, and then I was under the impression that it needed to be ascertained once it was addressed, and that it can be addressed at any time. And so I just kept pushing that line, and he was having none of it. So I feel like if I can make a record of that, am I right that since I brought it up at that?
Yeah, well, everybody's got to go at their own pace on this. Go with what you know to come back and push. But every time he comes up with an answer, you need to be able to answer his answer or sit down and say, you did not answer my question, what I've asked you. And two...
Well, and I did. I left the courtroom, saying, kind of talking to the record, saying, I do not feel I've been arraigned. I feel like this was being... I was, pushed through. I was rushed through this. I said that at least twice, and then I also, responded to him at one point because he kind of tricked me into answering a question. He made it seem like my answer was for everything he was saying, and I said that's deceit. So I definitely, raised objections and made on the record because it was recorded, and I'll print it out and enter it. I don't think they do. I don't know. I guess my question is, what should I do about the plea, about vacating it? I'm going to make a big stink about it because I'm just trying to throw something in the wheel right now to stop it from going further.
Well, this is the problem. You got to be able to, before you start throwing things in, you got to be able to defend what you're doing here, because there has been several people that has tried to sit down when the judge started asking, says, look, I do not have enough information to make a competent decision on what you're asking me. So that is something else that can be thrown into this, is that you do not have enough information to make a competent decision. So now that puts this judge into a place where he has to sit down and explain. And if you're still not understanding, in some cases, they will dismiss the case. Some cases, the judge are going to be, they're going to play hardball with you And instead of getting yourself thrown in jail or run the risk of contempt, play it by ear. If a plea bargain is the best part of this, then take the plea bargain. And I'm trying to give you the best advice on.
Yeah, I mean, I'm not worried about. Okay, they're saying 5 days in jail and a year offense probation. That's not really a big deal to me. You know, it'll probably just. I don't care. It's just the fact that I wasn't interfering with the peace and I wasn't doing this, and I'm just like, I want to get those declaratory judgments, and I want to kind of. This is like, you know, as you say, you know, time to play. And I know I'm not really able to play yet. I can't even like pick up the ball, but.
Well, again, I'm telling you, if you're not able to, you know, the choice is going to be yours of what you want to do on this. I've got.
Well, I know, right. I'm not very good when I'm in there, and I have to, you know.
This is going to be a judgment call on your side of this fence on what you want to do with this. It's going to be a judgment call on your side. All right?
Sure, yeah. I've already kind of made some call. I'm just kind of pretending like I can't turn around. But, you know, I'm obviously playing it by ear.
All right.
What do you think about
we've been on here for 3 hours, almost 3.5 hours. So let me get going. I got 2 more, and then I'm going to close this thing off after the last 2. Thank you.
Would you write a letter to the DA ahead of time before filing any court paperwork, or no?
I would. I would file paperwork in him and see what he does.
Yeah, I was just going to send him like a non-formal, court letter and just say, hey, man, I'm coming across a bunch of stuff, and it looks like it's going to get pretty hot and heavy in there, and I don't think you've evaluated the fact that there's really not a crime here, so don't get into it.
Well, like I said, you could try the birth certificate on this. You could come in and address the issue that this is an administrative issue. You know, you got a lot. You got a lot here. You got the fact that you were in an automobile. You wasn't in a motor vehicle. You got Title 49. You got Title 23, Highway Safety Act. You've got a lot of avenue here to get into and go back and play. And if you hold on a minute. If you get into episode 741, I go into the complete stuff on the Highway Safety Act and Title 49. So get into episode 741 on this and see what you can pull out of this.
Cool. Yeah, right now it's the art of subtraction. I've been through all your archives, and I just need to, you know, narrow it down and pick and choose and take it slow. Because I'm assuming, you know, if I come at them, it'll just kind of slow things down a bit.
Okay, well, just use your best judgment on this, on what you're doing.
Thanks.
All right, thank you. West Oklahoma, go ahead.
Hi, Rod. This is Angela from Oklahoma.
Hi.
I have a question. First for Harvey. The gentleman that was talking in regards to, I guess, your internet security, if it's okay with him and he sends Harvey some information, if he could email me that information, because I know he mentioned Skype, and I know Skype is they go through a VPN, which is a secure tunneling, which our government can't quite possibly know exactly where that secure tunnel is going to pop up. So I wanted to just, you know, read into whatever, I guess you would call it, internet service provider that he's talking about. Also, Harvey, are you still on?
Mm-hmm. Yeah.
Do you still have my email address?
I think I do, yes. I think I'll just put Angela in and it should come up.
Right, and if it's okay with him, I'd like to check into that. Also, I was doing some reading, and I ran across the word endorsement. And I know we spell it with an E, but however, this Barron's Law Dictionary basically spells it with an I. They refer you to the endorsement spelled with an I, and I thought it kind of looked kind of weird, the definition. So I'm going to briefly just read that. It says, signature placed upon the back of an instrument with or without other words, whose effect is to transfer an instrument and create a new and substantive contract by which the endorser becomes a party to the instrument and liable on certain conditions for its payment. The conditions giving rise to the endorser's liability generally comprehend the failure of the party primarily liable under the instrument to make payment in accordance with the terms thereof. It seems like to me it's off. I've heard it said somewhere that we're really not supposed to endorse the back of those checks. And if I'm reading into what I think I'm reading into, I know you've had 20 plus years in this. It seems almost like when a party issues us a check, rather than showing identification and being paid for it, when we sign it, we're taking on that liability.
Well, the thing is, you are, but on the other hand, what you're not taking on the liability, because even if you sign a check, have you been paid?
No, and it also states here the endorsements are made primarily for the purpose of continuing, negotiable, or enhancing the commercial value of the instrument. And it goes on to say that to constitute an endorsement, the writing must be effective to transfer the entire instrument to which it is affixed. Otherwise, it operates as only a partial assignment. And then it goes a little bit further and says an endorser is one who endorses negotiable paper. For instance, the payee or the holder of a check may endorse the check by signing it on the back. An endorser is liable to pay the negotiable instrument in the case it is dishonored, and we know it's dishonored because there is no money.
Well, see, this is the whole point. A lot of this stuff, you got to go back in, find out when these laws were written, and some of these laws were written prior to the bankruptcy, which they set up in order, so when they did the bankruptcy, to come in and complete the fraud on us.
Okay,
because under that bankruptcy, the way this thing was set up, like I said, because the government, it holds the liability of all Federal Reserve notes. Anytime you take a check down, you're not getting gold and silver, you're getting Federal Reserve notes. That check that's being signed is they're now securitizing off that signature. You follow me?
I noticed that, because from time to time, I will go to work for temporary agencies. Now they have a new thing. I guess this is their hunger to grab that signature. They now, years ago, I'm almost 50. When you went to go get a job, you would not have to sign a W-4 or anything until you were hired. Now they throw that W-4 up in your face. And you know, I noticed that this particular staffing company was operated. It was a LLC, which most of them are operated or owned by lawyers. And I told her, I said, I don't know if it's, if I should really sign this W-4 because I'm not hired, and I'm only hired if I get an assignment, And then they hand you a card, and I looked, and lo and behold, now they're attaching checking accounts to those cards. Which means that even if they don't call you in to work, you still open the checking account.
Yep.
Forward.
Like I said, if we go back and really truly understand the bankruptcy side of this stuff, the system is supposed to be on a discharge basis on all of this. It's supposed to be on a discharge. All we got to do is sign our name, and they go discharge the debt. But because if the fraud that has been perpetrated upon us to allow us to believe that we're supposed to have money in our pocket and that we was getting something tangible, in which what we was all taught, we went along with this. But until we got into the congressional records where McFadden come in and said, whoa, the Federal Reserve note is not money, but a mere promise to pay, and that your signature is the collateral on everything. That signature on that check is the collateral for the government to come back in and sell, for them to securitize and to create profit for Federal Reserve note, because your labor was going to pay for it.
Well, right. And also, Rod, listen to this. In the olden days, when you got paid cash, did you sign anything?
No.
No. But when you're paid by a check, you got to sign something that can then be taken out and floated and done stuff with.
And not only that, it's stating that you're creating a new substantive contract.
Yeah, right.
The only thing that you signed at that time was the payroll record to show that you received your pay.
Well, I remember jobs when I was a kid. I didn't even do that.
Yeah, but if you watch some of the old historical movies, like I mean like the old movies and stuff, they got in whenever people got paid. They signed the book that says, yes, I got paid. Here's my signature. This way, the owner could come back and say, okay, you signed it on this here date. This says that you did get paid.
But I don't think they took those signatures and did anything with them in those days.
But all it was is a record to prove that you got paid. Okay. All right, let me take one more call, then we got to get off this thing.
Okay, thank you.
Thank you. California.
Yes, Rod. I have two questions, relatively simple. Listening to the discussions about the A for V, I have a $40,000 truck. I got $6,000 balance on it. I can't make the payment now. They're going to want to take it. Can I acceptance for value the remaining balance through that credit union?
Again, like I was sitting here saying earlier, they would have to do the 1099 because if you go back in and address the bankruptcy side of this thing, if they would do the 1099, that truck would be paid for.
What do you mean by they do a 1099? Do they send me a 1099?
No, what they would do is they would turn around. Technically, any of these banks, loan companies, and stuff like that, because of the bankruptcy, the way the bankruptcy is set up, you go in, you sign a document, they would turn around and send that document with a 1099 into the comptroller currency or into IRS. This would cancel the debt, and this would pay off the public debt, and that vehicle belongs to you. You cannot sign a 1099 cancellation because you're not the one that is the creditor here on this. They are. They're giving you the credit.
Right.
Off your signature. So when you sign that note, technically, this is what I was sitting here saying earlier in the show on the banking stuff. When you go down to the bank and you sign that promissory note, that bank was required to take it to the comptroller currency because the state got the federal grant money off your Social Security to pay the bill. And they're not doing it.
Okay.
But the thing is, if you get this thing turned over to a third-party debt collector.
No, they won't. They'll just, it's a credit union. They'll just pick it up and auction it.
Okay, well, you need to try to make the payment on this thing if you're dealing with the same people here. Because like I said, right now, with what we're dealing with the local people, local companies, they're really not understanding this because what we're teaching here it's relatively new. Even though we are backing it up, and we've been able to prove in the last several years that when they take your signature, they do sell it, and that's the same thing with a car dealership. If you went through a banking, they did sell it. If you went through that car company, they do sell it. They do sell that mortgage note. They don't have that promissory note. Not the original.
Well, I think the credit union is doing the same because when I paid off the Cadillac, they sent me a letter saying that my payments were done. They didn't send me a copy of the original contract like they used to in the past.
Well, see, and they did not send you back your promissory note.
That's correct. They did not. And I didn't question it at the time, but since listening to you, I now understand what they're doing, and so I'm wondering why I can't just get the rest of this discharged because they've already been paid. I'll pursue that here locally and see what I can do. Next question was, we had a violent traffic issue. I questioned the officer why he wanted my information. Anyway, they pulled us out, took my truck, took my goods that I was hauling. The company that had the trailer sold the goods. I was dismissed through the arraignment process, and the person who was helping me move my goods was charged with obstruction and is now facing misdemeanor, and we can't seem to get them to budge on that thing. So here's my question. Did I understand you to say that the DMV actually controls and there's an administrative process that we can go and do something with against the officers and what they're doing rather than continue in the court?
Yep.
How do you talked about that in an episode, I believe, a couple of them. Do you remember what ones they were?
Yeah, go back into 741.
Okay, I'll do 741. When you do an administrative process, you just go down to the DMV and ask for a hearing?
Yeah.
Great.
You go back to the agency and you ask for a hearing because the DOT is the one that gave you your driver's license. The DOT is the one who owns the vehicle.
Well, now this is the person that was riding with me that was not a party to anything. They just ripped him out of the vehicle and charged him with obstruction.
Okay, now let me ask you a stupid question here, and this is an issue here that we're going to deal with here in Lincolnton. Was he placed under arrest first before they charged him with obstruction?
Well,
no, stop and think. That's what I asked you. Did the officer,
I know exactly what you're asking me.
I am now placing you under arrest. Did the guy, after the police officer said, I'm now placing you under arrest, did he resist or obstruct after he told him he was under arrest, or did the police officer charge him with this before he arrested him?
I believe he charged him before he arrested him.
Whoops!
However, in California, the vehicle code only allows for either a consensual stop or an arrest. It's considered a warrantless arrest if they will not let you leave under the vehicle code.
It doesn't make a bit of difference because what we pulled up here in the laws, and I talked to the U.S. Marshal up there in Washington, D.C., and I talked to the attorney, and I talked to the probation officer. So let me ask you a question here. Can you be charged for obstruction of an arrest before you are arrested? And they said, no way. You cannot be charged for obstruction until you were told you were arrested first.
Well, it's kind of interesting because I didn't get to see the whole thing, and they found my recording and turned it off, so I wasn't able to record, and they separated us. Then they proceeded to beat him up, and he was telling me that they kept telling him to stop resisting, and then long story short, I'm going to have to ask him in detail because we have written document. We've gone over that minutely, so I'll go back through that and find out. Then can we just go to the DMV and file that complaint?
Yep, go into the DMV. Actually, you want an administrative hearing on this issue.
Okay.
And what you could turn around and do also is you could go in and bring a claim into the administrative court out there. You're in California, right?
I am.
Go out there and I think Sacramento is your capital, right?
Correct.
You go out to the administrative court, you bring a claim. Was it a local cop or state patrol?
It was a county sheriff.
All right. So you go bring a claim against the county commissioners because they are the ones in charge of the county. And then you bring a charge against the sheriff's department in the administrative court. And then bring a claim against them for what they did under the Highway Safety Act.
And that's an administrative hearing?
That's an administrative hearing.
Okay.
And you ought to bring the governor into this because he is the one who is in charge of the Highway Safety Act. So then you got to bring in the Attorney General, and you need to bring in risk management. So you go after the governor, the Attorney General, the risk management, the county commissioner, and the sheriff, and you bring them in their name, not in their job capacity as public officials, but in their public name of who they are, and get them for breach of their fiduciary duty under that job.
Right. I understand all this. I understand it. I've been listening to you for a while. I kind of memorized all that. The problem I have is I can't put it on paper very well. Is there someone out here you know that can refer me, can help me put it on paper?
Oh man, that I don't have, and this is a major thing with what we're teaching. You know, you've got enough documentation of Harvey puts out that you could use my documentation as a template to go back and look, see how we do it. That's why we put this stuff out.
Yeah, I can do that. I'm sorry, I just slipped my mind. You do that, so that's fine. I can do that.
And
okay.
Just work it on that fashion, because if you can get your administrative hearing on this, now you can bring that. That's what I said earlier. You get your administrative ruling on this, then you can take them right into the claims court, and you can sue them in their private capacity in the claims court, and they can't have an attorney walk in. They got to come in on their own.
Well, they told us that we had to file complaints. We filed our complaint with risk management. They're dragging this thing on in the local traffic arraignment court, trying to wear us down, I guess. But by April 20th, we've got to have something filed in there, or we can't sue because the time runs out. So I'm looking for a way to perpetuate our action. And my assumption was that if I get into the administrative side of the DMV, that'll preserve our rights to go into federal court after them.
Well, yeah, you can, but you want to go into the DMV and then go into the administrative side of this thing, preserve it on the administrative side. But if you've already notified certain people here, you go back in and say, okay, I notified you on such and such date. I'm giving you a second notice here, because what you're doing is going under Rule 55. You first notified them. Under Rule 55, then you come back and say a notice of fault. It says, excuse me, obviously you're not paying attention, or you did not get the paperwork, but I'm notifying you for a second time. If they don't answer within 15 days, then you go back in and put a notice of default against them and ask for a summary judgment. And that's where you go back in. Now you're giving them 3 notice. Now you can do the administrative, and just because now they don't have a defense because you tried to communicate with that agency. They refused to answer you, so now you got the administrative court to go take them into.
Well, the reason they're continuing it is we've asked for all of the recordings, audio and video, from the initial stop to when they left the area, and they're just not providing it.
All right, well, now you go back in and file for a declaratory judgment or summary judgment because they failed to sit down and produce the document, and that goes under, I think, Rule 36 of the Civil Rules Procedure, that they're not cooperating under disclosure. And under Criminal Rule 14 or Criminal Rule 16 for failure to disclose. So now you can go back and get them under these 2 rules for failure to disclose.
And this is all federal?
It's also civil for state.
Okay. All right. Well, I don't know that much about that, so I'm going to have to learn in a hurry.
Yep. That's the problem with what we're doing here. A lot of this stuff is a cram course, and it's awful hard, because when I first got into this, and here in 2001, well, I got into it before that, but 2001, when I got my first traffic stop, I had a cram course, but I had a good teacher that I sat down and worked with. Within 6 weeks, I had enough knowledge that I could go play with these people because he crammed it into me, but I was a quick study.
Hey, listen, I got to tell you, I got to cram. I've got IRS, Franchise Tax Board, property tax on 5 properties that we can't handle, probate court going, murder investigation going, loss of income now, trying to pay current bills, and now this traffic thing as well. I'm a little overwhelmed.
Well, I understand that. They're trying to stretch us out with what we're doing here. They're trying to wear us out, but because they have all the time, and because they're being paid to go do this to us, that's where the disadvantage comes in. That's why we need to start going after them administratively. And don't wait for them to stop us. Don't wait for them to pull you over. Go bring an administrative claim against these people and start charging them under ultra-virus for misbehavior.
Well, I'll do the best I can.
Thanks.
Okay,
thank you.
Bye.
Yep. All right, ladies and gentlemen, this has been a long, long night. It's been almost 4 hours. This is the longest I've done for a long time. I hope the information you got here tonight was sufficient and educational enough for you to understand of what we're doing. Those of you who are new to the arena, do not try to walk in and go head-to-head with these people. I have walked into court with too many newcomers, and they tried, and the moment the judge started questioning them, they stammered, they stuttered, and they got hammered, okay? You've got to be able to have this stuff rolled off your tongue. If the judge sits there and says, What does it mean to drive? Your Honor, under the legal definitions of the Title 49 USC, Title 49 CFR, a driver is someone who gets paid commercially. I have not yet been paid. If they sit back and they ask you about why don't you want to hire an attorney? Well, why would I want to hire an attorney that has a bar card that can lose his bar card whenever you tell him under Rule 11, if he proceeds to defend me properly, you're going to have him disbarred and removed. You've got to have this stuff on the tip of your tongue. You've got to be able to roll with this stuff with these people. The moment you stutter, you hammer, then you've lost. That's why you've got to be able to know this stuff. And for you new people, if you're not used to this, if you can take the plea bargain, take the plea bargain. You can always go back and sue them because there is no statute of limitation on fraud. There's no statute of limitation on constitutional violations or civil rights violations, and there's no statutory law on racketeering on what they're doing to us because it's perpetual because they're going from you to someone else. So it is a continued motion of racketeering enterprise on their side. Learn, get educated, understand what you're doing here before you go jump into this. I do not recommend anybody using my paperwork unless you really truly understand the historical background of this stuff. But like I said, right now under the bankruptcy, the state is sitting as the administrator, they're sitting as the executor, they're sitting as the trustee on this thing. You're sitting as the beneficiary, but they are the ones who have to discharge the debt. You cannot write anything off your account because that account is under their supervision. That's like you trying to come in and write a check off your mom and dad's account and you sign their name. That's forgery. So we have to be careful what we're getting into. We got to watch and be very, very careful. So I want to thank you for being in here tonight. I appreciate you people listening and hanging in here as long as you have. We've got to be in court on March 26th. Donations is always welcome. What we're doing here for travel expenses, for what we need. It helps. And like I said, the documentation you guys are getting, Harvey's putting it out. They're not charging you for the documentation, so you're getting a wealth of information. And for what donations that we could get, that helps what we're out. This helps the printing. It helps the cartridge, because cartridges for the machine cost $75 for a cartridge. What paper cost, So all donations help with what we're doing. And those that want to donate, the address for me is P.O. Box 435 High, H-I-G-H, Shoals, S-H-O-A-L-S, North Carolina, 28077. Money orders, send me money orders. You leave them blank, I can fill them out, and I'll sit here and we'll put them in. But ladies and gentlemen, be careful with what we have learned. Another gentleman down here in just South Carolina coming home, back to North Carolina, got pulled over by a sheriff department. He was a 70-year-old man. He was asked to get out. He reached for his cane, and they shot him. The cop said, I thought he was going for a gun. He was reaching for a cane, and he got shot after he was told to get out. So even when the man was trying to come in compliance peacefully, they shot him anyhow. You need to look up the escalation clause in your state of how the police are supposed to operate. Check your escalation clause of how they are to operate, because when they are stopping you and they are shooting you, I don't care what they say, that's flat out murder. They have a progression that they have to deal with. And as long as you're not threatening that police officer, as long as you're not being aggressive to where you're coming after him, and that means that you're moving from your car and you're heading full steam at him. Standing there is not being aggressive. And for them to shoot you down, that's murder. So be careful out here with what you do. Thank you, and have a good night.
Thank you, Rod. Thanks, everybody.